May I please your lordship?
Yes.
I beg to mention two RSA. One is for listing. One is for 6th of May. Another is for 8th of May.
When do you want?
My lord,
When do you want?
6th of May. Another one is 8th of May.
Take it.
Highly obliged.
May I please, your lordship, I beg to mention for listing of one RSA matter in the orders column, any
When?
date after view vacations, your lordship.
May I please, your lordship? I beg to mention item number 7, your lordship.
Item number
7. Today, my senior have some difficulty, your lordship. So, matter
on the prayer being made by Mr.
T. Gogo, your lordship, on behalf of
Learned
India.
Counsel for the petitioner raises the matter after vacation.
Lordship, first week of May, your lordship.
Take a date from him.
Lordship.
Yes.
Lordship, I beg to mention for listing of the CRP IO for motion on 21st April, lordship.
21st April. How many minutes? 23rd.
Next date fixed for cross-examination of PWC is fixed on 24/4, lordship.
23rd.
Lordship on 22nd.
Okay.
May I please, your lordship? My lord, I beg to mention for listing of two pending matters after vacation, my lord, 23rd, my lord.
I please, your lordship. Lordship, item number 14, I beg to mention item for adjournment, lordship.
14.
Lordship.
The prayer being made by Mr. S. Pegu, Learned Counsel for the appellant, raises the matter after vacation.
May I please, your lordship? Mine one is also for listing,
When?
not coming for long day.
When do you want?
Listing.
Okay, all right.
Oh, yes, it's the date, 22nd to 24th of this month. 20? No, sir. Kindly give 22nd, 24th, or 28 to 29. Any day you can give. 24. Highly obliged.
Yes.
May I please, your lordship? I beg to mention listing of the RSA matter for orders on 23rd or 24th April.
23rd.
Yes.
May I please, your lordship? I beg to mention for listing of two MFPs, lordship. Both the matters are all pending matter, lordship. So matter may be come up after vacation, lordship. Any date, man.
Take a date from him.
5th of May.
Yes.
May I please, your lordship? I'm praying for listing of a civil revision petition, which any day after vacation. Can it be on 5th of May?
Yes.
May it please,
5th of May, can it be?
may it please, your lordship? Lordship, item 3 may be taken at 2, my lord.
Why?
Lord, some difficulty from my senior, my lord.
Okay.
At 2. Obliged.
May it please, Lordship.
Yes.
Lordship, I'm seeking your mercy and grace to transfer the MSCT matter which has been pending before the MSCT court number 3 to MSCT UP Arunachal Pradesh. My grounds for the transfer are, Lordship, the first ground is that the course of action, the occurrence of the place where the accident took place is in Papu Hill, district Papumpare, Arunachal Pradesh, which falls under the jurisdiction of MSCT UP Arunachal Pradesh. Second ground is, your lordship, the petitioner is a permanent resident of Arunachal Pradesh, which falls under MSCT court Arunachal Pradesh. And the third ground is that the claimant are also the resident of Lakhimpur, Assam. However, they have filed this suit before this MSCT court number 3, your lordship. Therefore, now the defendant number 1, who is a petitioner in this transfer petition, is a student aged about 19 years old. It's a
Petitioner
student
number
1. No, you're the petitioner in this transfer petition. The petitioner is the defendant number 1 in MSCT court. So he is a student aged about 19 years old, studying in a Deranatun college, studying second year. So it is very difficult for him to travel all the way to attend the matter. And secondly, the families of the petitioner is also facing some financial hardship to take up all the financial expenses of accommodation, transportation, and other expenses. So, Lordship, I want to read one section of MSCT Act 1988, Section 166, Clause 2. In Section 166, Clause 2, it is mentioned that every application under subsection Clause 1 shall be made at the option of the claimant, either to the claim tribunal having jurisdiction over the area in which the accident occurred. Your Honor, this is the accident occurred in Arunachal Pradesh. This is the first option. And secondly, the claim tribunal within the local limits of whose jurisdiction the claimant resides. Your Honor, the claimant resides on Lakhimpur. There is MSCT Lakhimpur also in Lakhimpur. And thirdly, carries on a business within the local limits of whose jurisdiction the defendant resides. Defendant is residing on Arunachal Pradesh. So, therefore, most graciously praying that your Lordship will consider my prayer and transfer the said to the
At
appropriate.
this stage, we will issue notice.
Yes.
Let the other side enter appeal. Enter appearance, thereafter we will consider your prayer. Third, Mr. Your good name, please.
Sibon Engti.
Shibon,
Engti.
learned counsel for the petitioner. In this petition under section 24 of the Code of Civil Procedure, read with section 151 of the Code of Civil Procedure, is referred by the petitioner, namely in some product for transferring MSC case number 1312 of 2024, which indicated Rohima Khatun and one another versus in some product and others pending before the Court of Learned Member, Motor Accident Claim Tribunal number 3, Guwahati. To the learned member, to the Tribunal of Learned Member, Motor Accident Claim Tribunal, UPA, Papanpara District. The learned counsel for the petitioner submits that the accident took place at Papunala of Arunachal District, and the petitioner herein also resides in where he is residing
App sector Naharlagan.
at a sector
App sector Naharlagan district Papumpare Arunachal Pradesh.
F sector,
Yes, sir.
sector F of Naharlagan, and further he submits that the petitioner is facing hardship to pursue the case at Kamrup, Guwahati, and he also submits that the respondents herein also hails from North Lakhimpur, and as such, it would be convenient for both the parties if the case is transferred to the Court of Learned Member, Motor Accident Claim Tribunal, UPA. The submission of the learned counsel for the petitioner needs further consideration at this instance. Notice be issued to the respondents, returnable employees that be taken by registered post with AD and also by usual process within a week from today. At what stage the proceeding is pending here?
Beg your pardon.
At what stage the proceeding is pending here?
The stage is filing of a written statement.
Written statement. Is there any interim pair here?
No. No, no.
No. Okay, at least after 4 weeks.
Much obliged.
Item 2,
Have legal lordship. Are you going to appear? Yes, sir.
Wait, please, Lord. But in fact, there was a delay condonation petition in this case, my lord, in which I appeared, I filed wakalatnama, my lord, but when the matter has been registered as TRP, my lord, my name has not been shown. My lord, may I please, my learned friend provide me a copy and it come after vacation, my lord, immediately.
No,
Heard Mr. Bhuya, learned counsel for the petitioner, and Mr. Dubey, learned counsel for the respondent. Mr. Dubey submits that his name is not reflected in the cause list. And the copy of the petition is also not available with him. And as such, he submits that the counsel for the petitioner may be directed to furnish a copy of the petition to him and to list the matter of the petition. Where is accordingly allowed, Mr. Bhuya, learned counsel for the petitioner, shall furnish a copy of the petition to Mr. Dubey during the course of the same. This shall list the matter immediately after reopening of the petition.
Let the registry show my name, my lord, because Wakalatnama is.
This shall also reflect the name of Mr. Dubey in the cause list.
May it please your lordship.
Yes,
My lord, the petitioner as a plaintiff filed a suit stating therein the father of the petitioner along with the father of the respondents were brothers. My lord, they were after their death, my lord, the respondents and the petitioner, my lord, in a Batwara case, they divided their share and partitioned their share. My lord, thereafter, my lord, in the portion which my share was given, some of the respondents has encroached over that. So I filed a suit for right title interest and khas position. My lord, during the time of cross evidence, cross of the defendant witness, my lord, after they filed written statement and others, my lord, I found a formal defect that the source of my title was not given in my plaint. So I filed an application for Order 23 Rule 1(3) to withdraw with a liberty to file. At the very first day, without ex parte, it was allowed. My lord, the other side came before the High Court. High Court said with a liberty to file a fresh one cannot be given with ex parte. So, my lord, it went back. The respondent filed a written objection. After they filed a written objection, my lord, the impugned order comes over, where, my lord, total infirmity of the factual position was there, my lord. The infirmity was that we want to show the source of title, and the trial court held, my lord, your lordship may turn, the impugned order starts at page 63.
yes.
And my lord, here the facts were there. May I read it slowly, my lord? My lord, 68 is the, my lord, the finding given, my lord. Your lordship may look into the finding. Your lordship will start at para 15. In my considered opinion, quoting a different source of title will not constitute a formal defect in the present set of facts. And something more important, no department has been able to show there is in effect the different source of title which was here to not brought on record for the reasons best known to the plaintiff. We don't want to show any different title documents for title. We want to show the source of our title. Where is the different title, source of our title, my lord? Where it is? And my lord, para 14, the court held we could have filed an amendment application at para 14. He could very well have filed an amendment petition, and then next page, my lord, it was dismissed. We are never bringing a fact of a different source of title. Our Order 23 application is at page, my lord. My petition is at page 45. 45. Your lordship will find, after stating the facts, what I want to state is in page 47, para 7. Page 47, para 7. May I read it, my lord? That although the plaintiff have absolute valid title over the suit land as mentioned in the plaint, but due to unavailability of document at the time of filing of the suit, the plaintiff was compelled to bring the suit erroneously on the basis of incomplete revenue record. And then next page, para 9, that due to the formal defect of the plaintiff will fail to establish his source of title over the suit land, as well as in the absence of relevant documents. The above mentioned relevant facts, the present suit will surely fall. And in that event, the plaintiff will suffer substantial. Hence, the plaintiff in need of institute a fresh comprehensive suit, including the entire, which covers such and cannot be done without leave of the honorable court. But where is the question of bringing a different source of title? Which document? My only case is I filed the suit. My plaint is at page, your lordship will find. My plaint is at page 15. Page 15, my lord, your lordship will find. suit for right title interest, confirmation possession over the land, Schedule A. My lord, I
Page
find
number,
page number 15, plain starts at page number 15, page 16, para 3. Para 2, it states, the plaintiff and the defendant are close relative and also same family. That the father of the plaintiff and father of the defendant late such and such, the father of the plaintiff late such and the father of the defendants are own brothers. As such, they are lived jointly along with their family members peacefully without objection from their family. The plaintiff applied for petition before the revenue authority regarding Batora of the suit land along with the other land. That as per Batora case such and such, the circle officer such and such, my lord, which separately in favor of plaintiff C. Ganesh Chandra Das as Pattada. In this way, the plaintiff acquired a Patta land such and such and such. The aforesaid suit land standing house over the land and house partition among them by a Batada case between the plaintiff and the defendant. That the plaintiff also acquired the middle part of the suit land which the defendant are occupied. They are denied to deliver the aforesaid land in favor of the plaintiff. The plaintiff also requests the defendant several times, but the defendant flatly refused it. Then, my lord, ultimately the prayer is the decree for passing such and such. My lord.
okay, yes, Mr. Das,
My lord, this matter relates to, my lord, whether there is a formal defect or not, my lord. If your lordship will kindly see the order, my lord. Their main case is that, my lord, they have not mentioned some facts, my lord. Whether non-mentioning of facts can be said to be a formal defect, when that can be cured by way of an amendment, my lord. And regarding non-production of documents, my lord, it is the duty of the plaintiff to state at the time of filing the suit as to whether those documents were in their possession or not. If they have no possession, then it is their burden, my lord, to state that these documents are in the possession of somewhere else and they should seek liberty to procure the same. Now, my lord will kindly see the impugn order at page number 68, para number 15. In my considered opinion, quoting a different source of title will not constitute a formal defect in the present set of facts and circumstances. And more importantly, no document has been tabled to show that there is in fact a different source of title. They did not even place those documents before the court, madam, where there is illegality. Lordship will kindly see their documents, madam, which they have furnished, madam, at page number 33. Page number 33, madam. This is a document, madam, certified copy, which they have obtained in the year 2017. 2017 certified copy, my lord, which they did not even produce. And the other documents, my lord, will kindly see at page number 39. This is a document at the bottom, my lord, procured in the year 2023. They did not, for some reasons, they did not place those documents before the court. Now, my lord, how can they say that there was illegality on the part of the court when they themselves did not produce those documents? So, my lord, the case is that, and in
no, they could not produce the document.
Yes.
So they want to withdraw the suit.
no, they could not produce the documents. That's a different thing. But when they filed the amendment withdrawal prayer, with the petition also, they did not enclose these documents. Suit is of the year 2017. They got the hold of these documents in the year 2017. Some documents they got in the year 2023. Amendment petition they probably filed in the year 2023.
No amendment application.
No, sorry.
Order
Withdrawal,
23 application.
withdrawal application.
With the liberty to.
Withdrawal application. So along with that application also, they did not enclose those documents. So that is why the court said that since they did not produce those documents, that is why they could not make up their case. So where is the illegality in that order, man? And they did not even state as to when they got hold of these documents.
Okay. Yes, Mr. Sodure, whether these documents were part of the petition filed before the.
No, my lord, these documents were not part of the documents. We have said that these documents were unable to file. That is the formal defect, my lord. That is the formal defect. Why documents were not there? That is why the suit is defective. That is why we want to file a fresh suit. What will harm them?
No,
If-
no, Mr. Sodure,
My lord.
whether this defect can be rectified by filing an amendment petition and.
My lord, the law of amendment, what I understood, my lord. Sorry, my lord, I'm giving, my lord, what, my lord, why, when can amendment be allowed, my lord? That is, my lord, it is stated that, my lord. My lord, para 7. It is 2019 4 SSC, page 332. Para 7. Para 7.
Yes.
Leave to amend may be refused if it is introduced a totally different, new and inconsistent case or challenges the fundamental character of the suit. The proviso to order 6 rule
That's
7.
all right. Whether these documents will change the necessary.
My lord, it will change the, because my whole prayer was to a Batawara. And now I have placed this source of title. That is, will change the character. And my lord, though normally amendments are allowed in the pleading to avoid multiplicity, the court need to take into consideration whether the application for amendment is made bona fide or mala fide and whether the amendment cause such prejudice to the other side. It will cause prejudice to the other side, my lord. Again, they have to change their written statement. They have to do everything. And here, my lord, if I am in delay in filing the suit, that can also be considered. They can take the plea in the written statement. Here, they will not suffer. Maximum, they are entitled to some cost for withdrawal. And I will file a fresh suit. They will be automatically, they will be given allowed to file a written statement. Maximum, my lord, they can be given a cost. If without a liberty, they don't have a right to oppose also. In order 23 rule 1(3), if I don't seek for a liberty to file, there is no question of them to get objection. But here I have asked for a liberty. That is why they are filing objection. But where is the source of title and title for a different, my lord, the language that is used by the trial court is, my lord, if the source of title or to have something else, he could have filed an amendment that is gone in the para 15, page 68. In my considered opinion, quoting a different source of title. Why for a different source of title, my lord? Because, my lord, the source of title will not constitute a formal defect. And my lord, next date is on 22/4 for cross of the defense and witness. My lord, this will not harm them in any way. What they want, so that I should ultimately fail in my suit. That is what they are asking for. I am not asking for a huge amendment or anything. My lord, I will withdraw. They are entitled to some cost, that much. On the all the pleadings what I have got from
Mr. Chaudhary,
my lord.
it will cause delay in disposal of the suit.
My lord, that will be a fresh suit.
Maybe.
My lord,
But
my lord, it is my suit.
till that he has been suffering.
My lord, that is why they will take a cost. They will take a cost. That is what, my lord, when I got through all this order 23 judgments, what I find the Supreme Court says, my lord, formal defect and a substantial cause. If it is a substantial cause, in 76 also our High Court has said, discussing everything, that is, they are entitled to only some cost.
So, first you tell me what is formal defect?
Formal defect is, my lord, the formal defect is that the source of title was not placed before that. In their written statement, they have said that that land has been sold to somebody else. So these things, if I don't show my source of title, that this land was never a part of mine, my father, never part of my father. That is,
let us do one thing. We set aside the order. We remand the matter to the trial.
my lord, and for a fresh consideration.
You file a fresh petition enclosing the documents, so you have plus.
My lord, that will do.
Or lordship may fix it on 21, my lord, for final hearing, my lord.
No, my lord, that will not do, my lord. That will not do
If
because
the matter is fixed on 22, lordship can fix it for final hearing
why,
on
my lord,
21st, my lord.
why not a hearing today when he is in a caveat? He will get the opportunity over there.
You argue the matter then.
Well, today is only for admission, my lord.
Maybe.
Yes.
Then there will be a stay order.
Lordship will admit it and fix it for hearing on 21st, my lord.
No.
So, are you interested to file any objection here?
My lord, I may crave your liberty, well, my lord, to place some judgments, my lord, of the Supreme Court, my lord, regarding whether these things, my lord,
These things will not be in a caveat
or not.
Then, my lord, there should be, because 21st on the very first opening day, but it will not be possible. Sometimes this is a vacation, my lord. It may not be possible to come on 21st. If he is not in a position to argue on a caveat, let it be after 22nd, my lord, we will argue, and my lord, till then the matter will be stayed.
Regarding stay, my lord, I have objection because it's a matter of 2017. 2017 suit, my lord. And regarding prejudice also, my lord, their evidence cross-examination is also completed, my lord. So at this stage, my lord, if this matter is allowed to be withdrawn, then also, my lord, we will suffer prejudice. my lord.
It,
So,
it causes, my lord, in a
So-
second appeal, it also is allowed to be withdrawn.
So
That judgment I have brought, my lord.
if your lordship wants to hear it finally, my lord, then my lord may fix it on 21, my lord.
No, 21 is not possible for me, my lord, because he doesn't come prepared with a caveat and he tells me to come on 21st. How is it, my lord? He files a caveat and he doesn't come prepared.
Okay. Suggested that
But matter is fixed on 22nd, my lord. So if it is not possible on before 22nd, my lord, then it's up to your lordship, my lord. Because stay, my lord, I have objection regarding stay. So if your lordship
then
wants, my lord,
let it
then
be on 21st.
my lord,
To come with
my lord.
relevant judgments then.
My lord, you are protecting us for a day, my lord.
No, on 21st we are taking the matter.
My lord, because
They-
he doesn't come prepared, my lord, your lordship has to balance the convenience. In a
No,
caveat, he
no,
doesn't.
no. Next date is fixed on 22nd.
My lord, so because on 21st, it will be difficult for me, my lord, because I'll be going out.
Mr. Hawk will appeal.
My lord, your lordship, if he is on an objection and without preparation, you are not giving, your lordship is not passing a stay order. Because he doesn't come prepared, my lord, your lordship has seen. I have given all the judgment. I have prepared myself. My lord, let it be on.
21st we will consider it.
My lord, why not, my lord, then your lordship has given an opinion, set aside and remand back and let them.
No.
My lord, on a caveat, my lord, on a
No.
caveat, he doesn't come prepared.
Mr. Sururi, fair opportunity has to be given to both the parties.
My lord, in a caveat 148A, he should come prepared, my lord. He cannot say that I have not brought judgments, my lord. Then I could have also not brought the judgments, my lord.
Maybe.
My lord, a one-sided affair cannot be there, my lord. It should be both sides.
Heard Mr. P.K. Sururi, learned counsel for the petitioner, and also heard Mr. S. Das, learned counsel for the respondent. Place the matter on 21st for further hearing.
My lord,
Caveator would be heard, caveat decides.
Highly obliged.
my lord, one thing your lordship will find, if on 21st something doesn't there, then on 22nd, my lord, at least your lordship give me one fair opportunity.
On that day, we will consider.
My lord, if on 21st something happens and my lord, we could not come, my lord,
Then we will consider interim care.
but that much will be there. That on that day, if something doesn't happen, my lord, the interim order will be considered.
Okay, we will consider it.
Highly obliged.
My lord, can it be parted, my lord? Your lordship was hard over it. Let it be parted, my lord. Let it be parted.
Okay, let it be part.
No.
My lord, in this case, the petitioner as plaintiff, my lord, was filed a title suit for declaration of possession of ownership by possession in 2011, my lord. And thereafter evidences were taken, and in between the COVID also came, my lord. And now he is aggrieved by the order dated 11/12/2024, whereby his adjournment petition was rejected on the ground that medical certificate has not been attached, and his further cross-examination has been dispensed with. My lord, the impugn order is at page 92, my lord. It says that both sides are represented. That is annexure 19. Plaintiff has filed petition number 3502 of 24, prayed to adjourn the date for today, fixing another date for cross-examination of PW1, that is himself, my lord, that is the petitioner, on the ground that PW1 Sri Madhav Borua is suffering from heart problem, high pressure, etc., and in a bedridden condition, as such unable to attend the court today. But it is seen from the record that case was fixed for the same stage from 11/9/2023 and has not submitted as supported medical documents. Plaintiff side on multiple dates have sought adjournment on ground of illness of PW1. Despite last opportunity, the plaintiff side again sought adjournment without any supporting documents. Hence, petition number so and so stands rejected and cross-examination of PW1 is dispensed with. Well, this order, although
Where
it
is
was
the medical document?
medical document is at page, my lord, 94, my lord. That is dated 10/12/24, my lord. On that day, he visited the doctor and he was advised 10 days bed rest, my lord. At the bottom is written, my lord, bed rest for 10 days. And then there is the date 10/12/24. He in
Okay, okay. Heard, Mr.
M. Khatonia.
And Katonia, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 11/12/2024 and 14/2/2025. Passed by the learned civil judge in Division number 1, Principal, title suit number 47 of 2021. In the 10. It is to be noted here that by impugned order dated 11/12/2024. Where is that order?
Well, that is at page 92.
The learned trial court
That is a type copy and 93 is the order, my lord.
has dismissed the petition number 3502 of 2024 filed by the petitioner for adjournment of the case on medical ground. On medical ground and by impugned order dated 14/2/2025. Where is that order?
My lord, that order. (24/2/25) is at page number 96, my lord. Last page.
By impugned order dated 24/2/2025, the learned trial court has dismissed the petition number 508 of 2025 filed by the petitioner for adjournment of cross-examination of PW2 on the ground that PW2 is out of station.
Well, that day was fixed for PW2 and his adjournment was allowed, but petitioner's adjournment, my lord, for considering the revision was not allowed, my lord.
No, on 24/2/2025, you have filed petition for adjournment of cross-examination of PW.
PW2, my lord, because
And-
I was PW1, my lord, my
And
cross was dispensed with on 11/12/24, that is the impugned order, and thereafter PW2's cross examination was fixed. And on 24/2, PW2 sought for adjournment and that was granted, but there was another petition to consider the case of the plaintiff as he was preferring a revision petition, but that was rejected, my lord, and next date was
Okay,
fixed on
okay.
23/4/2025.
by impugned order dated 24/2/2025, the learned trial court has dismissed the petition number 507 of 2025. Filed by the petitioner for granting him 2 months' time to obtain necessary order, the revision to be preferred by him against the order dated 11/12/2024. The learned counsel for the petitioner submits that the petitioner could not remain present in the court on cross-examination on 11/12/2024 on medical ground. And in support of his submission, he has referred to a prescription
Is there a
enclosed
10/12/24?
with the enclosed at page number 94 of the petition. And submits that the petitioner was suffering from
Diabetes.
ailment of heart and he was advised for taking bed rest for how many days?
10 days, my lord, at the bottom, my lord, advice bed rest, 10 days. Doctor's handwriting is very difficult. That is the signature of the doctor and just next to it.
Advice bed rest for 10 days. 10 days. And also he has referred to a document dated document at page number 95. Page number 95.
So this was the reference document of the prescription, ma'am.
Perusal of the aforesaid two documents, that is page number 94 and 95, 90, 94, 95
Yes, ma'am.
indicates that the petitioner was suffering from some ailments of heart, and doctor advised him for bed rest for 10 days, for which he could not appear before the learned trial court on 11/12/2024, for which the petition number 3502 of 2024 has been filed for adjournment for cross-examination of the PW1. Thus, it appears that sufficient ground was shown for failing to remain present in the court on that day by the present petition. Then on such ground, whether you have endorsed those documents with the petition.
My lord, this document could not be annexed on that date. Only information was supplied to the council, because on that, the day before that, he was already bedridden, my lord, and he had to go on 10th of.
Okay, taking note of the submission of learned counsel for the petitioner, then also taking note of the documents number 94 and 95. This court is inclined to allow this petition. The impugned order dated 11/12/2024 is then set aside in first, and the learned trial court is directed to afford one last opportunity to the petitioner for cross-examination of PW1. The petitioner shall appear before the learned on the next date is fixed.
The next date is fixed on 23/4/25.
23/4.
On that day, he will appear.
The petitioner shall appear before the learned trial court on the next date fixed on 23/4.
4/25.
In terms of above, this CRPI stands closed.
Item 6.
Obliged.
May I please, your lordship. Petitioner has challenged an order dated 7/1/2025 passed by the learned civil judge senior division number 2, lordship. The lordship will find the interim order at page 73. It runs from page 73 to 81. The plaintiff side has filed a petition, a suit seeking monetary compensation of rupees 40 lakhs, and we filed an order 7/11D petition on the ground of that the suit is barred by law of limitation, lordship.
Law
Law of limitation, lordship. Suit is barred by limitation.
But it appears that the trial court has considered that aspect.
Lordship. Sorry, lordship. Sorry.
The trial court has gone to that aspect.
Lordship, yes, lordship. Page 74. May I read page 74, lordship?
Not necessary, let notice go at this.
Lordship, apparently the suit is barred by law of limitation, lordship, because of the fact that, lordship, may I kindly see.
No,
Page 7.
prior to institution of the suit before the trial court, you have the other side has also approached another court.
Yes, lordship. The plaintiff side has filed a writ petition seeking compensation, and this High Court granted liberty to seek appropriate forum for further compensation.
So he will entitle to that period
Lordship,
as per
Article 14.
Article 14.
That Article 14 is not applicable, lordship, in my respectful submission, because High Court, Article 14, there are 4 conditions has to be fulfilled. The 4th number condition that this High Court does not have jurisdiction and return the plaintiff, only that in that point of time, Article 14 can be made applicable. But High Court at no point of time says that.
This is the will here. Or learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 1/7/2025 passed by the learned civil judge senior division number 1, Kamrup and Guwahati, in major case number 1157 of 2023, arising out of money suit number 89 of 2023. It is to be noted here that by the impugned order dated so the learned the civil judge senior division number 1, Kamrup and Guwahati, has dismissed the application filed by the petitioner under order 7, rule 11 of the Code of Civil Procedure. First, the petition and the documents placed on record, and also first the impugn order dated 7/1/2025. Let notice be issued to the respondents returnable in 4 weeks, that be taken by the third post with AD and also the usual process within a week from today. List after 4 weeks.
Lordship may kindly consider my interim prayer, Lordship.
Let the other say.
Because the trial court says that the right to accuse from the date of the judgment passed by.
We will hear the other say.
Lordship may kindly fix a date, Lordship, if possible.
Know that after 4 weeks, you take a step.
Lordship may kindly allow me to take Dusty in that case, Lordship.
Okay, dusty service is also permitted.
Lordship.
Met clear, Lordship. Lordship, here the petitioner has renewed his prayer for bail on the ground that at the time of arrest, no grounds were communicated to him by the investigating officer, Lordship. That page 71, your Lordship will find the notice. And page 73 is the arrest memo. And page 74 is the inspection memo, Lordship. And in this case, Lordship, co-accused bail has been fixed by your Lordship on 21st April 2025. So this matter may, along with the record, and in the meantime, they can obtain the instruction from the investigating officer, Lordship.
From?
From Sri Bhumi, Lordship. And that order, that connected case is
Heard
fixed
Mr. Ahmed, learned counsel for the petitioner.
co-accused bail application order.
Learned counsel for the accused and also heard Mr. KK for us, learned additional for the respondent. This application under section 483 of the BNSS 2023 is referred by the accused. Namely Abdullah Al Muhammad Soudhuri alias Abdullah Soudhuri alias Pablo, who has been languishing in jail as in connection with special NDPS case number 43 of 2023, arising out of Karimganj PS case number 334 of 2023 under section 21C 2529 of the NDPS side. Mr. Ahmed, learned counsel for the accused, submits that his application is, this is the second application.
Lord,
This is the second. bail
not
application
second,
is
Lordship, this
referred-
is the fourth application, Lordship.
Fourth application.
Fourth application.
This is the fourth bail application prepared by the accused. On the ground that while causing arrest of the accused, the grounds of his arrest were not communicated by the concerned arresting police officer. In order to appreciate the submission of Mr. Ahmed, learned counsel for the accused, perusal of the case diary is found to be necessary, and accordingly it is provided that resistant call for the case diary from the court of learned, where it is pending.
Special Judge Sri Bhumi, Lordship.
Learned special judge Karimganj,
Lordship, Sri Bhumi.
Sribhumi,
Sri.
learned special judge and PS Act Sribhumi, along with a scanned copy of the record. List the matter on. Is it the same PS case?
Same PS case, Lordship. He is the accused whose name is there in accused
21
number
four.
1. Page 27.
The question is whether the record will come or not.
Because in that case already records received, Lordship. I have seen.
21.
Problem. In this case also, Lordship, that he has renewed his prayer on the ground that no grounds of arrest were communicated to him, Lordship. That page 66, your Lordship will find the notice under section 50, Lordship. Page 66.
Heard Mr. Ahmed, learned counsel for the accused, and Mr. Orasur, learned additional PP for the state respondent. This petition under section 483 BNSS 2023 is prepared by the accused, namely Farooq who has been languishing in jail to take connection with the special entities case number 108 of 2022. Since 2/2/2023. Under section 22C, 25, 29 of NDPS Act. This is second, third, or fourth.
This is lordship third.
Mr. Ahmed, learned counsel for the accused, submits that this is the third bail application referred by the accused on the ground of non-communication of the ground of arrest by the arresting police officer at the time of arrest of the present accused. To appreciate the submission of Mr. Ahmed, learned counsel for the accused, perusal of the case ID and the case record is found to be necessary, and accordingly it is provided that register call for the scanned copy of the record as well as complete case ID from the court of learned.
Special Judge Sribhumi.
Thus, Sribhumi. Assam. Fixing the matter of
25th April.
25th April.
In the meantime, lordship, they may also obtain the instruction from IO whether
Verbal instruction will not do.
not that I think.
Letter will come.
Oblige, lord.
Lordship, this is a statutory appeal, your lordship.
Okay.
The suit of the appellant was dismissed, your lordship.
Third, Mr. Ayersum, learned counsel for the appellant. This appeal under section 96 with order 41 of the Code of Civil Procedure is directed against the judgment and decree dated 27/9/2024 passed by the learned civil judge, senior division number 2, Kasar Silsor, PS number 31 of 2009. Is to be noted here that by the judgment and decree dated so the learned trial court has dismissed the suit filed by the title suit number 31 of 2009 filed by the appellant hearing. Filed by the appellant hearing. First, the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents returnable in 4 weeks. That is taken by registered post with KD and also the usual process within your return today. Rescission call for the record from the learned trial court. Please submit after 4 weeks.
Oblige, your lordship.
Item 10.
May I please, your lordship? Your
Yes.
lordship, it is an appeal under section 173 of the MBA. Your lordship, my claim has been dismissed.
Why?
Finding of the court is that there is no evidence or materials on record to show that there was rash and negligent driving on the part of the motorcycle, alleged offending vehicle. Whereas exhibit 3, FIR has been exhibited, and in FIR, it is clearly written that the accident took place due to rash and negligent driving of the offending motorcycle.
Case has been registered upon the FIR.
Yes. Subsequently, final report has been given.
Final report.
Yes. 2% died, your lordship.
Learned counsel for the appellant. This appeal under section 173 of the MBA is directed against the judgment and order dated 10/1/2025 passed by the learned member, Motor Accident Claim Tribunal, Jorhat, in MSC case number 03 of 2023. This to be noted here that by review judgment and order dated 10/1/2025, the learned member, Motor Accident Claim Tribunal, Jorhat, has dismissed the claim petition filed by the present appellant. present appellant.
Your lordship, paragraph number 19. Thus, I find there is no evidence or material to come to any finding that the accident giving rise to the claim proceeding happened due to rash and then driving.
Where is the memo of appeal and the grounds mentioned therein? And also where is the impugned judgment? Order dated 10/1/2025. Admit issue notice to the respondents, returnable in 4 weeks, the be taken by registered post with AD and also by reserved process within a week from today. Justice will call for the record from the learned tribunal, is the matter after 4 weeks.
Highly obliged.
Item 11.
This is your lordship. Lordship,
Yes.
this appeal is basically filed on that the brother and sister will not be dependent as per Sarla Verma. And also, we had adduced evidence that the driver did not have a valid driving license, lordship. And on the other, like interest and also quantum, those are the grounds, lordship, basically.
Ms. R.D. Mazumdar, learned counsel for the appellant. Is appeal under section 173 of the MPA Act is directed against the judgment and award dated 12/6/2024 passed by the learned member MSCT number 1 Kamrup M. Guwahati in MSC case number 1 of 2016. So we noted here that by the impugned judgment and award dated so the learned tribunal has directed the appellant herein to pay a sum of rupees
10,58,000.
10,94,000
Oh, sorry.
400, being the compensation with interest at a rate of 9% per annum from the date of filing of the evidence on the affidavit, that is 13/3/2019. Date of filing of evidence on the affidavit of PW1. That is 13/3/2019. Where is the appeal and the grounds mentioned therein, and also where is the impugned judgment and award dated so and so. Admit issue notice to the respondent, returnable in 4 weeks, to be taken by registered post with ABS and supervisor process. This is the call for the record from the learned tribunal, is the matter after 4 weeks.
Lordship, though I is there, lordship, we do not want to deposit, we will not press it at present, lordship.
Okay.
Because we are not liable, brothers and sisters, settle law. Highly obliged.
May I please, your lordship, in this case, my claim petition was dismissed as per order dated 16/12/24. There was a delay of 366 days, lordship. Actually, petitioner could not file claim petition within 6 months because he was under treatment, lordship.
Petitioner was
Under treatment,
under treatment.
since at 3/23, lordship.
That's all right, but whether the statute provides for condonation of delay.
Yes, lordship.
Or miss, your good name, please.
KLR Yantan.
KLR
Yantan.
Yanta, learned counsel for the appellant. This appeal under section 173 of the MPA Act is directed against the judgment and order dated 16/12/2024 passed by the learned member, Motor Incident Claim Tribunal, Vishwanath Sariali in Miss case number 18 of 2024. It is to be noted here that by the impugned judgment and order dated so and so, the learned tribunal has dismissed the petition. Upon which Miss case number 18 of 2024 was registered, for condonation of delay of 366 days. Where is the memo of appeal and the grounds mentioned therein? Admit. Also where is the impugned order, judgment and order dated so and so. Admit issue notice to the respondents returnable in 4 weeks that be taken by registered post. ADN also by usual process within a week from today. Justice will call for the record from the learned tribunal is a matter of 4 weeks.
May appeal yourselves. Implement order is for 68 million. In this case, what happened? CW 3 Miller. He has stated that he himself driven the motorcycle with. But tribunal awarded against the owner of the motorcycle was the valid insurance policy Miller. That policy was not considered Miller. Some contradictory evidence is made before the tribunal Miller. CW1, CW2, CW3 Miller. PW1 also Miller. PW1 stated that his son and dad Funga Busmutari, as per CW1 Miller, IO Miller, stated that Funga Busmutari and Avinash Islari is sitting in a motorcycle and other motorcycle is knocked him Miller. But as per CW3 Miller, who has driven the motorcycle, he has stated that Funga Busmutari was the pillion rider Miller. And entire award is against passed against the claimant, my lord, appellant, who is the owner of the alleged motorcycle, my lord, who has the
So
valid
insurance was not there.
insurance is valid, my lord.
Valid.
Yes, my lord.
Then
Yes,
why the owner was directed?
my lord. That, my lord. Page 66, my lord. Which is submitted along with the written statement.
Page 66.
Yes, page 66, my lord. Third party liability.
Third party insurance.
Yes. Page 66 middle portion will a period of insurance from 26/5/2021 to 25/5/2026. An incident
Okay,
of
okay, let the notice go at the success, we will admit it.
yes. A notice may go in the
But Mr. Ahmed, learned counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment and award dated 10/2/2025 passed by the Lord and Member Motor Accident Claim Tribunal Siram in MSC, which indicate date case number 12/2023. Is to be noted here that by the judgment and award dated so and so, the learned tribunal has directed the present appellant to pay a sum of rupees 5,73,000 being the compensation. With interest at the rate of 6% per annum from the date of filing the application till payment of the award. Whereas the memo of appeal and the grounds mentioned therein, and also whereas the judgment and award dated so and so. Admit issue notice to the respondents returnable in 4 weeks that be taken by registered post with ADN also by usual process within a week from today. Basis will call for record from the learned tribunal. List the matter number for each.
Hello, my junior colleague would like to make the submission. My junior colleague would like to make the submission.
Your Lordship, this is an appeal under section 173 of the Motor Vehicles Act. And our main ground of appeal is that the injured claimant, he was an unauthorized passenger in the vehicle. Your Lordship, according to the insurance policy, this was a policy which was issued for demo cars. And there was no additional premium paid for any unauthorized passenger, Your Lordship. And the sitting capacity was also 0. This means that he was not even authorized, and as such, we are not liable for paying the compensation. He was not within the insurance coverage, Your Lordship.
Okay. Heard miss, your good name, please.
A. Biani.
A. Biani, learned counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment and award dated 23/12/2024. Passed by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Guwahati in MSC case number 1833 of 2018. Is to be noted here that by the impugned judgment and award dated so and so, the Lord Tribunal has directed IFL and hearing. So that is new in the assurance company limited to pay a sum of rupees 9,75,541 rupees, being the compensation with interest at the rate of 9% per annum from the date of filing of the claim petition, that is 6/9/2018. Whereas the memo of appeal and the grounds mentioned therein. Also, whereas the impugned judgment and award dated 23rd/12/2024. That may issue notice to the respondents returnable in forex that be taken by registered post with AD and also by usual process within a week from today.
Your Lordship, there's also an IA for stay.
Recessal call for the record from the learned tribunal is the matter of rules. So deposit 50% of the amount.
Your Lordship, at this stage, we may just issue notice
Okay.
and
Okay, only so.
much obliged, Your Lordship.
Number 16.
None appears for the appellant on call is the matter of petition.
My lord, this is second appeal, this related to the out of and my lord, promissory note, my lord. Two suits have been filed by the respondent. Suit has been dismissed. Against this two appeal has been filed. Appeal has been allowed. Against that appeal, this is the second appeal, my lord. The earlier one more second appeal has been filed, my lord, and your lordship is pleased to frame a substantial question of law and admitted the appeal.
How these appeals are related?
My lord, out of the same transaction, two suits has been filed. The two suits has been dismissed. Against that, two appeal has been filed, two appeal has been allowed. Against that appeal, two second appeal has been filed. And unfortunately, the both appeal could not be heard together, my lord.
Pardon?
Two appeal could not be listed together, my lord.
Okay.
Otherwise, my lord, this is the Lota Gur, my lord. The second is the P2 Gur, my lord. Husband, wife of the same transaction, my lord. If your lordship come over next page of your judgment, my lord. In fact, it's your lordship has framed the substantial question.
So same issue as to be framed.
Same, my lord. Exactly same.
Promissory note is also same, exhibit 1.
Yes.
Right. Same.
Only my name has not been shown in the causally. That may be reflected, my lord. Today, my lord. And thus.
Okay. No, in the cause list, your name is not reflected.
Yes, my lord.
Okay.
And thus.
At last, you pick on Mr. Das submits that his name has not been reflected in the cause list. Rest shall do the network.
Lord, there is a stay application also, my lord. Or it will be.
Let notice go at this.
Yes, my lord. One more prayer, my lord. RSA 1686/2024. Let it come together, my lord. Same, out of the same, my lord. This appeal.
RSSL list RSA number so and so.
186/2024.
RSA number so and so along with this appeal.
Must have.
In IA office.
19.
So this is injunction matter, my lord. What happened, my lord? Two rival parties, my lord. They are doing their business, my lord. The appellant from 1998, my lord. They are 2001, my lord. They are doing with their business. Now, they raised some dispute, my lord, regarding the trademark and trade dress. And correspondence were going on, my lord, for last 6 months, my lord, from June onwards, June 24 onwards. Ultimately, what happened, my lord? They filed a commercial suit. My lord, in a commercial suit, your lordship knows, my lord, that first, my lord, it should go to the mediation, my lord. Here, my lord, the mediation has been followed. First thing that my this, it is not a case
where, my lord, the urgent relief is needed. Because for last 6 months, my lord, correspondences are going on. It is there. So in commercial suit, as a commercial court act, my lord, the matters should be so immediate that, my lord, they are. So when for 6 months correspondence is going on, it is not a case, my lord, where this should be exempted. Mediation. And an order should be passed. Now what happened? On 10th of January, an order has been passed. Injuncting me, my lord, granting injunction. My lord, it was an ex parte injunction. Order 39 Rule 3, my lord, provides that they have to take steps within 24 hours. My lord. They have not taken steps, my lord. That, my lord, I shall place your lordship that they have taken steps, my lord, after 11 days, my lord. 11 days. And there is a, my lord, if, my lord, this is done, my lord, the order should be immediately vacated. We have filed an objection, my lord. On 30th January, what happened, my lord? The learned trial court again extended the order, my lord, fixing 5-3, my lord. It is more time has been granted.
First, you show me the impugned order.
Yes, I am sorry. That has been stayed by the Honorable Court. My lord, impugned order is at page, my lord, 24. The main part, my lord, your lordship, my lord, come to page 29, my lord. Paragraph 9, my lord. Paragraph 8, my lord. At this stage, your lordship got it, my lord? Paragraph 29, page.
Page 29.
Yes. Paragraph 8 of the impugned order. First, that is the order. Actually, my lord, the matter requires full-fledged hearing. This hearing of the miss case amounts to hearing of the appeal also. Virtually. Because many things are there, I have to place it. Virtually, it's a final hearing.
Look, can we do it?
My lord?
Can the final hearing, we can do it?
I have nothing to say, my lord. But last day, my lord, that is why I my lord, because that are
Page number?
Page number 29.
25. It is
29. The miss case. 325 miss case. My lord, that impugned order starts at page 24. I am just placing the, my lord, main the considerations, my lord.
order dated 10/1/25.
Yes, ma'am. 10. I'm reading from the paragraph 7 also. This application has been filed by the petitioner seeking a temporary injunction against the opposite party due to the alleged violation of the petitioner's copyright and trade dress. The court, in deciding that this petition, is obliged to discuss the 3 fundamental principles of granting an injunction. In the following discussion, we will endeavor to outline these principles in the context of the petitioner's claim. At this stage, without addressing the merits of the case, the court has carefully reviewed the petitioner's contention along with the submitted documents. It is evident that the petitioner is the owner of a copyright and trade dress associated with the name Arham. Furthermore, P numbers 1 appears to be using the trade dress and copyright belonging to the petitioner. I shall place how he is wrong, as demonstrated by the documents on record. The court, without delving into the case of the merits, acknowledging the petitioner as the rightful owner of the trade dress and copyright under trademark Arham, sells rice products under this designation. However, OP are found to have using the similar trade dress along with composite mark of their own rice products and closely resemble the petitioner's trademark and trade dress. Well, by pausing here, I shall come to one of the pages, my lord, where both the symbols I have annexed. Your losses may just come to page 233. Today we have filed a rejoinder also, my lord, here. Page 233. This is their, my lord, left-hand side, this is their, my lord, trademark and this, that is what they say. And right-hand side is our 233. Your lordship got it, my lord, 233. How these are similar, my lord? I could not understand, my lord. Supreme Court also said, my lord, that when the mark is different, how persons will be swayed. But I could not understand that. You will also see that this is Jane symbol. This is not the original document, my lord. I shall place that also. That also they cannot. This is the Jane symbol, my lord. They are saying. Name is also there, Lunia marketing. Our is Joy Baba marketing, my lord. Our is, my lord, swastik symbol. This is Hindu symbol. How these two things are similar, my lord? I do not understand.
No, barring some features are
Some
most of the features are same.
Some features may match, my lord, but how? Main thing is the symbol. Main thing is the symbol. I shall place a judgment on the Supreme Court, my lord. This is the thing. Other, my lord, this rice, premium quality rice is there, premium quality, everybody sells, my lord. Everybody sells premium quality rice. Address is given, address is different. They have given Arham, we have given, my lord, Jai Baba. How is that similar, my lord? Otherwise, 100% pure, everybody right, 100% pure. Except that, my lord, what is the like? My lord, how one can copyright it? Copyright, my lord, my symbol is absolutely different. My trademark is different. Even, my lord, they were not given exclusive right to use this symbol. My lord, in the trademark, 248, you'll also see. At page 248, I shall come about everything I shall place, my lord. 248, one sentence I shall place. You also got it, my lord. The conditions, the last third one, registration of this trademark. Got it, my lord? Shall give no right to the exclusive use of the device of swastik palm and other descriptive matter. This is their registration. Our symbol is from 1998 and they are using it from 2001. Place, my lord. Well, this is not a case, my lord, where injunction have been granted, my lord. I said, yes, my lord. Because 6 months correspondence are going on.
Okay.
And commercial suit, my lord, it should have gone to the mediation, my lord, first.
So your first point is that they have not taken a step within 24 hours.
No, that is not taken. Now, in this aspect, my lord, I shall place a judgment of the Delhi High Court. Yeah.
And they have taken a step after 11 days.
My lord. My lord, and moreover, my lord, in the lower court, the view vacation is up to 15th only, not more than that. My lord, paragraph 25, page 14, your losses may see the judgment, my lord.
Paragraph number 25.
25. This is also a case of, my lord, infringement of that section of the. Huh? citation is, it is 98 AR Delhi 126. AR 98 AR Delhi. The crucial test to be applied for judging an infringement action or passing an action in the field of medicinal and pharmaceutical preparation remain the same as are applicable to other goods. 1998 P 126. However, in the case of preparation of trading whereof is governed by the statutory rules or regulations, additional considerations become relevant. They are the manner in which the trade is carried on, such as sales being made only by the authorized or licensed vendors who will be educated and also having special knowledge of medicines and pharmacy. I'm skipping over that. Subpara 3 may be seen. Nobody can claim exclusive right to use any word, abbreviation, or acronym which has become public juris. My lord, this is the giant symbol is public juris. This is not their own creature. I have annexed the documents also, joint, my lord. In the trade of drugs, it is common practice to name a drug by the name of the organ or ailment which it treats or the main ingredient of drug. Such organ or ailment or ingredient being public jurisdiction or generic cannot be owned by anyone for use as a trademark. Whether such feature is a public jurisdiction or generic is a question of fact. If the two trademarks by the two competing traders are a generic word and a exclusive public jurisdiction common to both trademarks, it has to be seen if the customers who purchase the goods would be guided by the use of such word expression or would ignore it to give emphasis to the prefixes or suffixes. And the words is in association therewith. The primary question to be asked is that what remains in the memory of the customer. The surrounding circumstances such as presentation of the goods, color of the scheme, lettering style used in the packaging also assume significance. Now I am coming. My lord. Then your losses may come to paragraph 31 to 36 regarding this order 39 rule 3. Paragraph 31, page 18. Your lordship got it, my lord? In view of our finding, the defendant's trademark is neither deceptive nor confusingly similar to a plaintiff's trademark. A case for grant of injunction is not made out. It is not necessary to deal with the plea. The defendant appellant is disputing the plaintiff's respondent's entitlement for grant of an interim injunction on the ground of delay in bringing an action. However, we would like to deal with the plea raised on behalf of the defendant appellant before us, just as it was raised before the learned single judge, though unsuccessfully demanding the uninstantaneous vacating of the ex parte order of injunction, even without going into the merit of the case, solely because plaintiff respondent had failed to discharge the obligation mandatorily cast by the proviso to Rule 3 of Order 39. The plea was set out in paragraph 4 of the defendant's application and Order 39 Rule 4 as follows. That plea has been given, my lord, that he has not taken steps. Now, your lordship may come to paragraph 34, my lord. Looking at the scheme of Order 39, CPC, it is clear that ordinarily an injunction may not be granted ex parte. The opposite party must be noticed and heard before an injunction may be granted. Rule 3 carves out an exception in favor of granting an injunction without notice to the opposite party where it appears that the object of granting injunction will be defeated by the delay. Conferment of this privilege on the party seeking an injunction is accompanied by an obligation cast on the court to record the reasons for its opinion. An obligation cast on the applicant to comply with the requirement of clauses A and B of the proviso. Both provisos are mandatory. The applicant gets injunction without notice, but subject to the conditions complying with the clauses A and B above. We may refer to so and so, my lord. Now I am skipping over this also. Your losses may come to paragraph 30. The next page, my lord, the last paragraph, paragraph 35. Assessing power in this aspect, in respect of some other non-compliance, there will not be said the order so passed, but the same cannot be said to be in proviso to Rule 3 of Order 39. The Parliament has prescribed a particular procedure for passing an order of injunction without notice to the other side under exceptional circumstances. Such ex parte orders have a far-reaching effect, as such as a condition has been imposed that the court must record reasons before passing such an order. If it is held that the compliance with the proviso aforesaid is optional and not obligatory, then the proviso by the parliament shall be futile exercise, and that part of the rule 3 will be a surplus for all practical purposes. Proviso to rule 3 of order 39 of the court attacks principle that if the statute requires a thing to be done in a particular manner, it should be done in the manner and not at all. We are of the opinion that if the court is satisfied that non-compliance of the applicant with the proviso contained in the proviso, then on being satisfied, the court which was persuaded to grant an ex parte injunction confiding with the applicant and that having been shown intelligence by the court, he would comply with the requirements of the proviso. It would imply simply vacate the ex parte order of injunction without expressing any opinion of the merits of the case, leaving it open to the parties to have hearing on the grant or otherwise the order of injunction, but by party only. The applicant would be told that this conduct to be more appropriate. He has deprived the opponent an opportunity of having an early or urgent hearing on merit, and therefore ex parte order of injunction cannot be allowed to operate anymore. Well, this is happening. Well, my submission is this, my lord, this is not an empty formality, my lord. First thing is a commercial suit, my lord, that I shall test, my lord, that mediation is a must, my lord. Here, when, my lord, the correspondences are going on, if you also see, since June, my lord, correspondences are going between the two parties. Notices are being issued by one party to other, my lord, reply. These are going on for 6 months, my lord, if you also see. Since 6 months, my lord, correspondences are going on. This is not the case, my lord, where the exemption should be granted by the court below. First thing. Second thing, my lord, ex parte, this is not a case for granting ex parte order also, my lord, because this is not a violation, my lord, at all. Hardly, my lord, this had not been, steps had not been taken, my lord, here. And we filed an objection, and that has been, my lord, actually, the court has passed an order which is at page 249, my lord. Because within 1 month, ex parte order, within 1 month, it should be disposed of, my lord. Now here, the earlier order, my lord, this is the order 249, my lord. Para 6. The contention of the learned counsel for the OP defendant number 1 is that prisoner plaintiff did not take steps upon him within the stipulated time as mandamus on order 39 rule 3 of the CPC. It further submitted that petitioner plaintiff was not required to wait for a certified copy of the identity order. Why certified copy necessary, my lord? That is not necessary. Apostate provision does not mandate certified copy order to be served on the opposite party defendant, but mandates a delivery of copy of plain petition and all supporting documents upon the defendant on the date of such order, and further mandate to file a compliance affidavit. Hence, OP number 1 has failed to recall the order so and so. Upon hearing and perusal, it appears that the main objection of the OP is regarding non-taking of the steps to the prisoner within time as provided and so and so. Considering the facts and circumstances under which administrative injunction order has been passed, it appears if the OP continue to use the alleged trademark of the petitioner, it will lead to multidisciplinary proceeding as well as likelihood of causing injury to a petitioner business. Considering that the prayer of the petitioner for extension of the identity order that is allowed, irrespective of the so and so, and accordingly interim order that is so and so extended, and 5(3) is fixed. My lord. This is the case, my lord. This is, my lord, my point has not been considered at all, my lord. He says, merit, whatever merit may be there, my lord. Huh?
So your part is complete.
No. Actually, I'm mentioning, sir.
We'll resume after 5 minutes.
Well, so far copyright is concerned, my lord, it should be original artistic work, my lord.
Pardon?
Or it should be original artistic work. If we have an exclusive right over the sale. And this has been, the Black Law Dictionary also says a descriptive edition, my lord. I'm giving it. What is a copyright, my lord? Very good. Have a copyright. my lord. Copyright is in the bottom left-hand column. It starts next page, my lord, and next 304.
No, is it not defined in the Copyright Act?
Copyright Act, yes, my lord, Copyright Act, my lord, I remember Copyright Act also, yes. But this is, my lord, yes, Copyright Act, my lord, you also.
If the definition is
Yes,
there
yes.
in the act itself,
Yes.
why should we go for
My lord, I
this, meaning?
here, my lord, actually, no such definition, my lord, who got the copyright. Here it has been defined, my lord.
Artistic work.
White work, my lord. This is the copyright work. This is why, my lord. Section 2Y. Page 9.
Yes.
Means any of the following works: a literary, dramatic, musical, or artistic work. So and so. Work a joint authorship means a work produced in collaboration of two or more authors, which is so and so.
Okay. So what are the other points?
Now I'm here, my lord. Both the parties are from Kolkata. Both the parties are from Kolkata. Without filing a suit at Kolkata, my lord, they have come to Guwahati and filed suit. My lord. This is one of the aspects of the matlab, your lordship's history. And this interim order, this injunction order has been stayed by the Honorable Court on 10th of February 2020.
Yes.
10th of February. This is going on, my lord. Now, page 89, my lord, if your lordship come, my lord, this opposite party, my lord, applied for the copyright in 2010, my lord. 10/1/2010. And the other page, my lord, I have already shown, my lord, to your lordship, my lord, that it is not an exclusive right to them, my lord. And so far, joint symbol is concerned, my lord, if your lordship see at page 32, 34, annexure 4. This is the joint symbol, my lord, which is they have adopted. Both parties are same, my lord. Actually, swastik is also a Hindu symbol. We have my lord, adopted, my lord, for the state. And they have also, so they cannot have, my lord, exclusive right over a symbol, my lord. This 234, 235, my lord, is given, my lord. And Arham, my lord, they have used Arham. Arham is, my lord, is a Arabic word. Arham means compassionate, merciful. This word is also not, my lord, their origin. And trademark, they have, my lord, their registration of trademark was, my lord, and we have applied for the trademark, my lord. That is at page 237, my lord. 237. This is, my lord, our, if you also see, Joy Baba. Also. We are also registered trademark owner as well as copyright owner, my lord. Joy Baba Vakrasar. It is effective from 21st of July 2006, my lord. Now, 241, my lord, if your lordship find another page. We have filed this application for copyright, my lord, that is in 2003 itself. And we are using this symbol, my lord, at page 244, you'll also find. We are using this symbol since 31st July 1998 at serial number 7. Proceed.
1998.
1998, since 1998. Bye-bye. Okay. Now, my lord, I shall come to the, my lord, the one of the Supreme Court judgment, my lord. This is 2000 5 SCC 573.
Which is the relevant paragraph?
Yes, I am coming, my lord. Paragraph 16, then 23, my lord, 25 to then, my lord, the main part first is your lordship may come to, my lord, paragraph 47 at page 596. Yeah. 573. Paragraph 37, my lord. May I read, my lord? This paragraph. The first question, therefore, is what on the facts are essential feature of the plaintiff's mark is clear from the, apart from the word picnic. The essential features of the special script of these words in block letters and the curve in which these words are inscribed and the caricature of the boy with a bad hat occurring between the words sick, K and on the plaintiff mark. On the other hand, defendant's mark contains the word picnic. My lord, here they have used not K, my lord, but C, picnic, in a straight line, in a script in normal, and the word Cadbury is written above the word picnic. Neither the peculiar script nor the card nor the boy with the hat are found in the defendant's mark. It is true that there is phonetically similarity that is used in the word picnic, but what is the effect of this similarity? Now your losses may come to, my lord. Paragraph 43. Section 29 use the word deceptively similar, and section 22(1)(d) defines deceptively similar as situations where one is deceiving the other or the confusing others. We have to keep in view that the distinction between the word deceive or confuse used in section 21(d). These words occur in various trademark statutes have been explained in so and so and so. Looking at to the natural meaning of the word, I would make two observations. First, the offending mark must so nearly resemble that registered trademark to be likely deceive or confuse or deceive or cause confusion. It is not necessary that it should be intended to deceive or intended to cause confusion. You do not have to look into the mind of the user to see what he intended. It is its probable effect of the ordinary people who have to consider. No doubt, you find that he did not intend to deceive or cause confusion. You will give credit for success of his intentions. You will not hesitate to hold his use of it is likely to deceive or cause confusion, but it has no such intention and was completely honest. Then you will look carefully to see whether it is likely to deceive or cause confusion so as to find guilty of infringement. Now, my lord, your lordship may come to paragraph 52. Next page. In the present case, the defendant's goods contain the word Cadbury on the wrapper. As per principle laid down in the so-and-so case, the occurrence of the name Cadbury on the defendant's wrapper is a factor to be considered while deciding the question of passing off. Similarly, in King and Co. versus so-and-so and Cadbury so-and-so, it was held that presence of defendant's name on his goods was an indication that there was some no passing off even if that dress was similar. The fact that picnic's defendant's wrapper contains the word Cadbury above the word picnic is therefore a factor to be taken into account. As to the scope of buyer being deceived in passing of action, he is not passing of action, my lord. Virtually both are registered. The following principles have to be borne in mind in so that it's a misconception to refer to a conclusion that can be created upon an ignorant customer. The kind of customer that confers ought to think of these cases is that customer who knows the distinguishing characteristic of the plaintiff's goods. Those characteristics which distinguish his goods from other goods is market so far it relates to general characteristic. If he does not know that he is not a customer whose view can be properly regarded by the court, so and so, which was passing off. In true case, Elsbury, if a person is so careless that he does not look and does not treat the label fairly, but takes the bottle without sufficient consideration and without reading what is written very plainly, indeed, on the face of the label, you cannot be so deceived. In our view, the court in present case went wrong in the principle holding that there is scope for the purchaser being misled. The conclusion was arrived is without above the principle. Now, paragraph 58. Coming to the question whether appellate court was right in inferring with the discretion of the trial court and in vacating the injunction, are of the view that facts of inference were justifiable. If wrong principle were applied by the trial court under Order 39 Rule 1, the appellate court could certainly interfere in the interlocutory proceeding under Order 39 Rule 1 CPC. Hence, the trial court gave importance to the phonetically similar and did not refer to the differences in the essential feature. It does not have the very customer in mind. On the other hand, High Court's approach in this behalf was right. It noticed that dissimilarity is the essential feature and concluded the view that as a whole that there was neither similarity nor scope for deception nor confusion. No doubt, both the courts went into the validity of the plaintiff's registered trademark and the question of distinctiveness of the word picnic under Section 9(1)(e), but in our view was not necessary. Thus, the wrong principle were applied by the trial court while refusing the temporary injunction. The High Court could certainly interfere. So and so, so and so. Okay. My lord, here, what I am submitting, my lord, that my main, the trial court's judgment, my lord, that order, interim order, I have just placed one part only. I'm just placing another part. Paragraph 29, paragraph 30, I was placing, my lord. Your lordship got it, my lord? Paragraph 30, page 30. Page 30.
Yes, 30.
30. Here, my lord, here I have placed this first sentence, my lord, from the idea. However, the OPs are found to be used similar trade dress along with a composite mark from 29 owners for their own rice products, which clearly resemble the petitioner's trademark and trade dress. How it resembles, my lord, trademark? Your lordship has seen, my lord, how trade dress is similar. And they say it is green color. We are using various color, my lord. I have got copies of the bags, my lord. Yellow color, green color, pink color, my lord. These colors are there, my lord. I have got, my lord. All the colors bags are there. Many colors bags are there. Now, this usage constitutes a violation of the petitioner's intellectual property right. Intellectual property right, where from intellectual property right? Well, causing significant inconvenience and harm to the petitioner. This court also reviewed the documents submitted by the petitioner, which include a caution notice published in various newspapers across India. It is noted that upon discovering the OP's use of the same trade dress and copyright, the petitioners issued notice on June 1924. My lord, this is what I said, my lord, that under Copyright Act, when they had correspondence are going on since June 24, there was no, my lord, urgency of passing an expert interim order. and exempting them from going to the this mediation. OP responded, followed by a counter response from the petitioner. Additionally, it is revealed that petitioner holds a registered copyright featuring artistic elements, including a hand symbol and a swastika OP. OP is using a symbol of the same color and company style, and along with the descriptive terms of 100% pure brand Sortex BPT rice, which constitutes a violation of trade dress and artistic design. Consequently, court finds that there is a bona fide disposition. And this is the main paragraph, my lord, on which the trial court has been. Well, how it can be, that is why Supreme Court says, my lord, this is absolutely different, my lord, symbols. The customer cannot be, my lord, fooled, my lord. Your lordship is seen at page 33, my lord. Their symbol is joint symbol and our symbol is swastik. Then their mark is Arham brand. Our is Joy Baba swastik brand. How that can be similar, my lord? Premium quality rice, this is normal, my lord. Let's say everybody say 100% pure.
Okay, okay.
So this is not a case, my lord, where the injunction should be granted, my lord.
Okay.
Much,
Yes.
much.
Let I take it from my learned senior colleague, my lord, that the case, my lord, which has been run by the appellant is on 3 grounds, 3 or 4 grounds. My lord, number 1, your lordship takes, my lord, with regard to Order 39, Rule 3. That was number 1. Second, my lord, that the trademarks, that is Arham, that is swastik, those are different from each other. And Arham and swastik both are descriptive and in certain ways relate to some symbols of religion, and they cannot be a monopoly of anyone. That is the second point. Thirdly, there is no copyright over the whole getup of the plaintiff, that is the respondent number 2. And thirdly, my lord, that the getup of both the plaintiff and the defendant's products, the packaging, are different from each other. Now, my lord, your lordship, if takes up, my lord, 3 or 4 paragraphs of their appeal, of their memorandum of appeal. What is the ground on which they have made out their appeal? Kindly takes up their memorandum of appeal once. It's very important, my lord, because my learned senior friend, my lord, has stated a lot of things with regard to Order 39, Rule 3. No extension should have been granted. But there are certain fallacies, my lord, on the basis of which, my lord, this appeal has also been filed. Very unfortunately, there has been 2 suppressions which are very, very important to this appeal. Because your lordship would keep in mind, it's not an Order 39, Rule 1 and 2 hearing. Your lordship, kind, I have not. My lord, it's an appeal from an ex-party order. This is not an appeal, my lord, after exchange of affidavits. This is a very, very important thing, my lord. Your lordship would kindly keep in mind in respect of an appeal arising out of an intellectual property matter. The other point which was stressed on was the Section 12A dispensation under the Commercial Courts Act. I'll address your lordship one by one on this. My lord, your lordship kindly takes up their appeal against which order the appeal has been preferred. My lord, in the synopsis, or my lord, in the appeal itself, memo of appeal, if your lordship kindly comes to the memo of appeal, and the first statement which they make is, being aggrieved and dissatisfied with the order dated 10th of January 2025. Now, the order which they come up against your lordship is 10th of January 2025. That is the first order of injunction. My lord, after that, my lord, if your lordship, my lord, kindly takes up their stay application and comes to page 249.
Yes.
Kindly comes to page 249, paragraph 4. This is the order which was passed on 30th of January 2025, where, my lord, they had filed an application being petition number, my lord, has 580, my lord, 581 of 2025, with a prayer for recall of the order dated 21st of January 2025. That was the order which extended the order of 10th of January 2025 upon an objection on the basis of an application filed by the plaintiff, that is the respondent number. My lord, before the trial court, stating the reasons as to why they should be allowed to serve upon the respondents at a delayed position, and upon considering the reasons, that application was allowed, granting the petitioner to serve a copy of the plaint and the petition after that period of 11 days. I take your lordship to that order first, my lord. If your lordship, my lord, comes to the stay petition, at page 23 of the memo of appeal. Yes. Kindly comes to that. Page 23 of the memo of appeal. It's their document. I'm not showing any of the document which have been relied upon in my affidavit in opposition till now.
Yes.
Kindly comes to page 23 of the memo of appeal.
Yes.
21st of January 2025, a petition number 479 of 2025 filed by the petitioner, praying for allowing the petitioner to take steps, stating that the injunction order was passed by this court on 10th of January 2025 at around 5 p.m. Kindly mark the time. From the next date, 11/1/2025 to 15/1/2025, the court was closed on account of Bihu. On 16 January 25, due to lack of court staff, petitioner failed to obtain certified copy of the order dated 10 January 25. The certified copy was received on 18th of January 25 and steps have been taken today. Hence, petitioner prayed to consider the same and to allow the petitioner to take steps upon the OPs. Heard the learned counsel appearing on behalf of the petitioner and perused the case record. On perusal of the case record, it is seen that the injunction order was passed on 10 January 25 But as the order was passed in the evening, the petitioner failed to take steps on that day. Subsequently, the next day, that is 11 January 25 to 15 January 25, falls on holiday on account of second Saturday, Sunday, and Magh Bihu holiday. Thereafter, on 16/25, due to lack of court staff, the petitioner failed to obtain the certified copy dated 10 January 25. That after receiving the certified copy of the order dated 10 January 25, on 18, the petitioner immediately on 20th January 25 have taken steps. Considering the aspect and the ground shown in this, I deem it fit to allow the prayer for petitioner. Accordingly, prayer filed by the petitioner dated 479 is allowed. Against that order, they file a recalling application. That recalling application, which was showing to your lordship, my lord, that is recorded, my lord, in the order, which is at page 249 of the stay application. He files a petition for recalling of the order of 21st of January 2025, which order extended the time, extended the order of 10 January, and also gave the liberty to the petitioner to serve upon the respondent. There, my lord, your lordship sees OP has filed with a prayer for recall of the order as well as raised objection against the extension of interim order dated such. Heard perused. The contentions of the learned counsel for the OP defendant number 1 is that the plaintiff did not take steps upon him within stipulated time as mandated under Order 39 Rule 3 of the CPC. It is further submitted that petitioner plaintiff was not required to wait for a certified copy of the said ad interim order, as the aforesaid provision does not mandate a certified copy, but mandates a delivery of the plain petition and supporting document. Hence, the AP defendant has prayed to recall the order. Upon hearing the perusal, it appears that the main objection of the OP number 1 is regarding non-taking steps by the petitioner within time. Considering the facts and circumstances under which the ad interim order dated has been passed, it appears that if the OP number 1 continue to use the alleged trademark, it will lead to multiplicity of proceeding, as well as there is likelihood of causing injury to the petitioner. Considering this, the prayer for extension, kindly mark this paragraph 9. Considering this, the prayer of the petitioner for extension of the ad interim order is allowed irrespective of the objection raised by the defendant number 1. Accordingly, the order dated 10/1/25 is extended till date. Now your lordship sees thereafter fix 5/3/25 for written objection of OP number 1, SR and such and such. Now your lordship sees this extension was granted on the basis of the petition filed by the petitioner for the prayer of extension, which is recorded at paragraph 3 on petition number 582 of 25. So which is the application which is disposed of granting the extension of the interim order is 582 of 25. The application number 581 of 25, which is the prayer for recall of the order of 21st of January 2025 is pending. It has not been disposed of. In view of an application pending before the trial court, being number 581 of 2025, and where objections have been directed to be filed, he comes off on the self-same cause of action before this High Court, my lord, in appeal not being able to get it recalled. Two parallel proceedings now. He suppresses this in his appeal, that this application of 581 for recalling of the order of 21st of January, which merges the order of 10 January 2025, was filed. The recalling on the first day was not allowed and it's still pending. No document till date to show that it has been disallowed, it has been disposed of. My lord, if now on the basis of this, the appellant, what the appellant has to do is, the appellant has to proceed, my lord, under that recalling application before the trial court, get it heard, and file an appeal against that. Second issue, my lord. Now, the second issue. There is no appeal preferred against the order of 21st and 30th. No appeal.
Against the order.
Of 21st of January, extending the order of 10th of January, and my lord, the 31st of January 2025. If he says the recalling application, which was the recalling was not allowed on the first day, on 21st of January 2025, then he has to come up in appeal against that order of 21st January 2025, which he does not do. So if he does not do, files an appeal against the order of 21st of January 2025, thereby the order praying for a recalling of the order on the basis of order 39 rule 1 and 3, on the basis of order 39 rule 3 does not survive. He has to go file a written objection or a reply to my order 39 rule 1 and 2 before the trial court and get the application or injunction application heard on merits, number one. Now, the third issue. He has taken the point of suppression in my petition. With regard to what? With regard to twofold reasons. One, that I have not disclosed that documents which were exchanged between the parties, which to show delay and why dispensation under section 12A should have been allowed. Those documents are there before the trial court, which we had filed.
I never said suppression. I never said suppression.
Yes, there is. I'll show it from the grounds, from their petition. I'll show it from their petition, from their appeal grounds. What is the point taken? Kindly comes to my lord, the grounds which they have taken in the appeal. Yes. Kindly comes to ground 16. For that, the respondent number 1 has obtained the impugned judgment and order by suppression of material facts, inasmuch as the respondent number 1 has suppressed that the respondent number 1 did not have any right in respect of the device of swastik palm in any manner whatsoever, and hence could not claim any copyright over the same. Then, my lord, your lordship comes to my lord, the stay application. Now your lordship sees what they allege in the stay petition. paragraph 5. From a perusal of the documents annexed with the said application, it becomes evident that the respondent number 1 and the appellant have been exchanging correspondences with regard to the alleged infringement and passing off of the respondent number 1's mark and copyright for a considerable period of time. A perusal of the notices exchanged between the parties would also reveal that the appellant had specifically disputed the right of the respondent number 1 with regard to its alleged mark or copyright, and that further indicated the appellant's mark does not in any manner infringes or interferes with the alleged mark and the copyright of the respondent number 1. Then your lordship, my lord, comes straightway, my lord, to the end of the stay application. Yes. Paragraph 39. And it comes to paragraph 39. The respondent number 1 has obtained the impugned judgment and order by suppression of material facts, inasmuch as the respondent number 1 has suppressed that the respondent number 1 did not have any right in respect of the device of swastik palm in any manner whatsoever, and hence could not claim any copyright over the same. Now your lordship sees. They say that I have suppressed that I did not have any right in respect of the device of swastik palm. My case is not on the device of swastik palm at all. My case, as your lordship has rightly pointed, observed, my lord, immediately when my learned senior colleague was making the submission, it's on the overall getup. That was the observation made, and I bow down to your lordship. It's correct. It's not on only the swastik palm. It's not only on the swastik. It's not on anything. It's the manner in which it is represented and the color adopted by the appellant. I am not on that. Now I'll show your lordship, my lord, the two packets physically. They are now here in black and white. I'll show your lordships physically, which is very, very required. I'll just hold it up, my lord, from here, and then I'll hand it over to your lordships. Kindly. Is it possible for any person going to a rice shop and purchasing rice? My lord, your lordship knows, my lord, much more than I do. Rices are kept in sacks. They are taken out on some cups or something like that of a bowl and poured in another small sack and given in loose bundles to the customers. Is it possible for any person? I'm saying. I have not asked them to stop their business. And my learned friend has very candidly has admitted today that they have various colors in which they are selling. Now, the various colors in which they are selling also adopts the same arrangement. The way it is written by me. Same arrangement. Why the same arrangement? Your lordship kindly sees, my lord, I'll just hand over a colored copy. I have, my lord, relied on this in my affidavit in opposition, but these are colored copies, for which reason I'm just handing it over to your lordship, which is annexure P1 of my affidavit in opposition. Oh, it's there with your lordship. I have been, not been, my lord. Kindly comes to the affidavit in opposition. Annexure P1. And this is the arrangement which I have given, the way their marks have evolved. Kindly comes to me. annexure P1.
Yes.
This was one of their mark which was used, still continuing. Then your lordship turns over, comes to the next page. This is another of their mark they use. Then your lordship takes the third one. Slowly, my lord, the marks come closing closer to us. Slowly. Then your lordship takes the next page. Then your lordship takes the next page. I have no quarrel against these. They have so many representations of packaging, but they'll have to come now closer to me and stick to the same style of arrangement and color. This is dishonesty, your lordship. This is dishonesty. When they have 6, 7 varieties of packaging, they can adopt any one of them and use it. They will not. Now your lordship takes up the next one. They have another one. I may take, my lord, some of them, my lord, may be backdated. My lord, these packagings does not attract customers. I take it, my lord, some of the sacks, maybe, my lord, black and white, like young people may not like it nowadays. My lord, they have other things also, my lord. They have colorful packagings, which they don't use. Then your lordship sees the last one, the last, second last, and my lord, then your lordship sees some of the after that, my lord. It becomes absolutely that of mine. My lord, your lordship sees what was the necessity. Mine, your lordship would see, has the same square border or the rectangular border within which my Aram and other things are written. He writes swastik on the same border. He adopts the same color. Then, my lord, that 100% pure, I'm not on, you write 100% pure, you write swastik, you write whatever you want, but your arrangement will be the same as that of mine. I'm on the arrangement and the color. I have a right on that. And it's not that they don't have, they have plenty. One after the other, my lord, your lordship sees, my lord. One after the other, my lord. And now your lordship, my lord, just compares this brand which they are using, the overall getup, with that of ours, my lord, which is, my lord, is in their stay application. Page 13 of our affidavit in opposition.
Page number
13, my lord, 1-3. Kindly see, my lord, we have done a comparison. My lord, page 273 in your lordship's copy, my lord.
Yes.
Kindly see. Everything, one after the other, one after the other, it comes in the same way. Aram and swastik written in that same shield or that ribbon style. The 100% pure at the same place. The square, the rectangular border, absolutely the same. My lord, thereafter, the way it is portrayed, it is absolutely the same, the style. Now your lordship sees, Malad, the fallacy, I'll just now compare the two orders. That is the order passed by the learned single bench, that is the learned trial court on 10th. And now the order passed by the learned appeal court by this high court. The two grounds which were taken. I'll just show your lordship. Now your lordship comes to the order passed by the single bench, by the, my lord, sorry, my lord, by the trial court. Yes, my lord, your lordship, my lord, kindly comes to paragraph 9 at page, my lord, 29 of their stay petition.
Yes.
The court, without delving, now your lordship would kindly take this into consideration. The court, without delving into the case's merits, so it was a prima facie view, acknowledges that the petitioner has the rightful owner of the trade dress. So there are two things, trade dress and copyright under the trademark Arham. Now your lordship sees the mark under which it is sold is Aram Swastik, no problem. Then sells rice products under this designation. However, the OPs are found to be using a similar trade dress along with a composite mark for their own rice products, which closely resemble the petitioner's trademark and trade dress. So it was a comparison of the trade dresses. The arrangement in which the parts or the factors in that trade dress are represented. That was found to be similar. And an injunction order was granted on the trade dress, not on the mark, not on anything which the appellant has tried to demonstrate or file in the appeal. Then your lordship, my lord, straightway, my lord, comes to paragraph 13. Paragraph 13 at page 32, my lord. As a result, an ad interim temporary injunction is hereby granted, restraining the OPs, including their directors, promoters, shareholders, partners, officers such and such, and my individuals claiming through any contract with defendant or OP number 1 from infringing the plaintiff's registered copyright and or the composite label attached as annexure B. So it was the trade dress or the composite, uses the word composite label. It is not on anything there. Now your lordship sees that the learned trial court explains. This includes using identical artistic features, containers, poly pouches or bags as shown in paragraph 19 and annexure F, and any deceptively similar marks either visually or phonetically or any colorable imitations thereof. He uses the word colorable imitations thereof. They are also restrained from using, advertising, selling, offering for sale or exhibiting for sale rice products or any related goods, from passing off or attempting to pass off their rice and cereal products by using identical labels or trade dress, and from using any color scheme, style, get-up, arrangement, or packaging that is deceptively similar to the petitioner's original design. So he restricts it. He says that trade dress, and that is also limited to what? He says limited to color scheme, style, get up, arrangement, or packaging that is deceptively similar. He doesn't extend it to swastik. He doesn't extend it to anything that is how it is written, pure rice, 100% rice, nothing. He says that trade dress and the color scheme, style, get up, arrangement. That's all. There also, the defendant has a difficulty. Even when he has so many colorful packets. And your lordship, then your lordship sees, my lord, the ground on which they have come up in this appeal. The ground, I'll just show to your lordship, just 4 or 5 grounds, is wholly on the basis of the merits of the case. Kindly comes to, my lord, paragraph. I leave out 4 and 5. I'll address your lordship later on that. 7. Ground 7 of the memo of appeal. It's wholly on merits. For that, the learned judge failed to appreciate that the mark and the alleged artistic work were invalid. I'm sorry, my lord.
Okay, we'll resume at 2 o'clock.
Madam. It will take some time.
Item 19 to continue.
My lord, my learned friend has come from Kolkata. He will complete his argument. So far, my reply is concerned, my lord, may pray that it may fix on 23rd. I have to go out of place, my lord. So,
Okay. He has spoken.
So,
I have no.
Okay.
So I said just a short reply, my lord. And
Okay. Yes, we are on paragraph number 7.
The stay application.
Oh, sorry, there's a ground number 7 in the memo of appeal.
Yes, sir. Your lordship sees, my lord, the case which has been built out wholly on merits. Now, if they have come out, if they have built up their case, my lord, on merits, perhaps, my lord, from an ad interim stage, without any application under Order 39 Rule 4 being filed before the learned trial court, and with a recalling application pending, when no documents are annexed, they file a recalling application on the ground that Order 39 Rule 3 has not been complied with, and they choose not to file a recalling application under Order 39 Rule 4 with the documents, but thereafter, after Order 30, the recalling application is disposed of, choose to come up in appeal against the main order. Very peculiar. They take time to file a recalling application on the ground of Order 39 Rule 3 not being complied with. They don't file an Order 39 Rule 4, choose to wait. The Order 39 Rule 3, that recalling application, the order they don't get, they come up in appeal against the first order. So in substance, what happens is the 21st January order not challenged. The 30th January order or the 31st January order not challenged. The order of 1st January challenged, 10th January challenged, without any recalling application filed after the recalling application for order 39 rule 3 disposed of, and they come up in appeal on merits. Now, another peculiar thing. The documents they rely upon, which they cannot do, my lord, in an appeal against an ex parte order, unless and until they comply with order 39 rule 3. Now, my lord, this honorable court, my lord, is not a high court having an original jurisdiction. Now, in a high court having an original jurisdiction, yes, they could have, my lord, without filing an order 39 rule 4, perhaps they could have come up in appeal and say on the basis of the plaint or on the basis of the petition, see, this is the way I am being prejudiced, taking the statements made in the petition and the plaint to be true and correct. And the learned judge has erred in passing the order because of these pleadings in the plaint. And because of these suppressions. Nothing more, nothing less. Here also the same thing. Here he could have come before your lordship saying only to the limited extent that see, these pleadings which are made in the plaint are false or there has been a suppression for which reason I am prejudiced. Done. Nothing's there on this appeal other than completely on merits that they have been using it since such and such period, that there is a disclaimer on the word on Aram and on which the cause of action of the plaint is not, and that the two documents are the two labels are different from each other. They say that because swastik and Aram is there. I put a question to myself, isn't it going completely into the merits of the case? The judge has passed an order on a prima facie basis. If they were so prejudiced, they should have filed an application under order 39 rule 4 saying that there were suppressions. He says in the appeal that there were suppressions. What was the suppression? That there was a disclaimer, the only suppression perhaps, which they can say. And I'm not on that. The cause of action of the plaint is not on that. It's not on Aram. It's on the getter. Now they also suppress a few things. They have not said that their word swastik has also been disclaimed, which they have themselves admitted in a suit before the Honorable High Court, which is annexed to my affidavit in opposition. Kindly come to my affidavit in opposition. Now, I didn't want to go into this because they are delving into the merits of this, which the learned trial court or the commercial court has the complete jurisdiction to deal with. If he has been so prejudiced, he waits for 20 days, files an appeal. Now your lordship kindly takes my affidavit in opposition. That kindly comes to me. Kindly comes to page number 307. They don't say all these things. They keep mum about these things, even in appeal. They don't come with clean hands and they say my Aram is being disclaimed. Kindly come to page 309, where they themselves got an injunction on the getter. Page 307 is their suit. Now your lordship sees page 309. The plaintiff has categorically stated that there is a disclaimer, and as such he is not praying for injunction with regard to the mark But he has drawn the attention of this court by producing the original gunny bags of rice, which has been used by the plaintiff as well as the defendant, which clearly shows that the defendant is using the similar get-up of the swastik mark in the rice bag. It's again the get-up. Considering the submissions made by the counsel for the plaintiff, and after perusing the materials on record and original gunny bags produced, finds that the plaintiff has made out a prima facie case, balance of convenience, and thereafter an order is passed on the basis of the get-up. Now your lordship takes the next, another suit which was filed, which is at page, my lord, 311, and kindly comes to 312. The second paragraph. Since there is a disclaimer on swastik, again, it's on the get-up. The plaintiff has produced two printed plastic bags, one used by the plaintiff while the other is now being introduced in the market by the defendant. On having a look at the said two plastic bags, it appears to be deceptively similar. The defendant is using the word new as a prefix to swastik. The prefix is printed in such a manner that it is likely to escape. Although the purchaser and manufacturer such and such, an ordinary buyer is not expected to make a pre-practice survey. Then, my lord, your lordship kindly comes to the last. In the aforesaid circumstances, the defendant is restrained from any product, particularly rice, packed in the plastic bags or any other package, as shown in Annexure M, that is the get-up of the petition, under which the defendant is selling its product, and the same are deceptively similar to those of the defendant, those of the plaintiff. My lord, they themselves say that there is a disclaimer on swastik. No one has any right on swastik. That is why they go always on the get-up against everyone. I have also gone on the get-up. I am not against swastik or anything else. I am on the way of arrangement and what the color and things they have adopted. And now, my lord, your lordship, my lord, just takes up, my lord, comes to, my lord, the memo of appeal. Or, my lord, I'll go to the stay application straightway. Kindly see what is the case which has been made out wholly on facts. I'll just give the paragraphs. I won't read those paragraphs also. Paragraph 7 at page 6 of the stay petition, it goes on facts that the marks and trade dresses are different. That is, my lord, in my humble submission, has to be decided upon, my lord, pleadings being complete before the commercial court. New facts cannot be brought, my lord, by the appellant at the appeal stage without filing any affidavits or reply, my lord, before the commercial court. And how they have relied on new documents, kindly sees. They come up in appeal and they file a section 151 application saying that these documents needs to be introduced for proper adjudication of the matter. If proper adjudication of the matter is done, has to be done, it has to be done before the commercial court. It's an appeal. If it's an appeal, they had to bring in those documents by way of Order 41, Rule 27. That has not been done. They file a section 151 application. And that also they state that these are required only for the proper adjudication. They don't say as to why they have not brought these documents before the learned commercial court at the first instance. My lord, paragraph 7. Then, my lord, paragraph 8. Again, my lord, paragraph 9, completely on facts. Paragraph 10, 12. Paragraph 13. 14, 15, 18. Paragraph 19. Now, my lord, I need to deal with paragraph 19 a bit. Because my learned friend had said, my lord, there was no allegations of suppression. Such factum of registration existing in favor of the appellant, both in trademark and in copyright, has been suppressed by the respondent number 1, despite being clearly aware thereof. In all the communications exchanged between the parties, the appellant has clearly and categorically stated that it is the registered proprietor of its mark along with the owner of the copyright. Now your lordship sees, my lord, what is the copyright and what is the mark, what on which they are registered. Kindly comes to, my lord, annexure 6, my lord, which is at page 242.
237.
One second. Yes, kindly comes to, my lord, page 237. Kindly comes to page 238, what they are registered. Your lordship kindly comes to page 241, which is the copyright registration. And see the document of registration, at page 244. That is the copyright which is registered, similar to that of the trademark. And then your lordship kindly comes to page 2. That's all. These are the two. The cause of action of the plaint, does not relate to remotely to these two registrations or to these two get up, or I am asking for any cause of action against these. It is the whole thing. So how is it a suppression of material fact? It is not a suppression of material fact. My learned friend their client has not been able to show that they have a registered trademark of the label which they are using, nor have they got any copyright of the label against which this suit has been filed. Not one document to show that registration. And they say in their pleadings that there is a suppression with regard to the two marks. My cause of action does not relate to this. And they say it's a suppression of material fact. That cannot be. That's not necessary. I'm not on that. I've not challenged it. I've not injuncted it from using it. My prayers are not there.
Okay, what are the other relevant paragraphs?
Lordship, paragraph 21. All are on facts. Thereafter, my lord, then your lordship, my lord, kindly comes to what he says with regard to the learned judge has heard. Paragraph 35. Sorry, my lord, paragraph 28. Learned judge failed to appreciate that the appellant is a registered proprietor of a mark. Cannot be a new fact which is brought in the appeal. It's not a suppression that can prejudice him. Paragraph 29, parties have been exchanging correspondences disclosed in the plaint. It's not that it has been suppressed. I have said that annexed documents, correspondences, replies to my cease and desist notice. There is no suppression to that effect. Then your lordship comes to paragraph 32. Artistic work were invalid, again a matter of fact. Paragraph 33, again the same thing. 34, 35, all minor. Proceeds on the basis that till 40 proceeds on the basis, sorry, till 39, it proceeds on the basis that the marks are the parts of the mark, swastik, brand, the way swastik is represented, aram is represented. They are different, they are Arabic words, that is it. These were never there before the learned trial judge. So the learned trial judge, my lord, in my humble submission, could not have erred in passing the order other than any suppression. There was no suppression. Other than the two registrations, they say, which registrations are not relevant for this suit at all. I have never prayed for it. Now, my lord, only two paragraphs of the order, which was, I have shown the order, my lord, which was passed by the learned trial judge. And now, my lord, the commercial court. And now, my lord, your lordship would kindly look into the order which was passed, my lord, by the Honorable High Court on the first day granting the stay. Kindly seize the first, sorry, just. The 10th of February, my lord. Yes, ma'am. Kindly comes to, my lord, the order of 10th of February, and your lordship straightway comes to page number 5. The learned counsel for the appellant submitted that the impugned interim injunction order dated 10th January 25 is liable to be set aside since the parties have been exchanging correspondences for a substantial period of time, and hence there is no urgency in moving the matter. Ex parte and the respondents have approached this court without satisfying or complying with the mandatory provisions under section 12A. He further submitted that the appellant is a registered proprietor of a mark and also a registration holder of the copyright. Hence, there is no infringement of any law under the mark. The learned counsel also submitted that the mandatory provisions of Order 39 has also not been fully complied with while issuing the impugned order dated such and such. Then your lordship sees Then your lordship sees, my lord, I'm sorry, yes. Considering the nature of the prayer made by the learned counsel of the appellants, this court find it fit to stay the operation of the impugned order dated 10, such and such, till the next date of hearing. Now, what was the three things which were made out? Number one, your lordship sees the paragraph previous to that paragraph. Granting temporary injunction by restraining the present applicants from using, advertising, selling, the applicants would be facing huge monetary loss and would suffer irreparable loss, injury and prejudice. Now your lordship sees, nowhere does it say that they will be restrained from manufacturing or carrying on their business. Nowhere. The preceding paragraph itself does not record their submission. But they go on to say, we'll be facing huge monetary loss, irreparable loss, injury, and that is why the stay was granted. I've shown it to your lordship, my lord. They have a number of packaging which they can use other than this, and they can file their affidavits and everything before the trial court, bring the documents on record, and thereafter hear it out on merits before the commercial court. It is not that they will be prejudiced 1%. It is the get-up, the dishonesty on the part of the appellant to adopt an identical get-up, an identical color, and an identical representation of the parts of the mark. Next issue, my lord, what they have said with regard to 12A. That is, correspondences were going on. My lord, there are, my lord, judgments which I'll just rely upon of the Supreme Court saying why 12A is necessary and under what circumstances the 12A dispensation should be granted or should not be granted. And there is a Delhi High Court judgment which takes into consideration 12A in respect of an intellectual property suit and says why 12A dispensation is a must. Now, my lord, again, just on facts, one issue. In a 12A, if your lordship takes up the Commercial Courts Act once,
Yes.
kindly comes to 12A. A suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. So what does it say? Two things. One, the suit which does not contemplate any urgent relief, like a money suit, which does not contemplate any urgent relief, shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. So, some sort of a suit where an urgent relief is not kindly mark the word, is not, it does not say not necessary. It says which does not contemplate. That means a suit from which any urgent relief shall not be necessary at all. Like a clear-cut money case, like a clear-cut money suit, where the defendant is not taking any steps to render the decree which can be passed in favor of the plaintiff infructuous by selling of his property or anything. So it says it does not contemplate and says that here a mediation should be followed so that the matter can be settled between the parties and it does not come to the court and burden the court. The object of the legislation is this. Now your lordship sees. My learned friends have themselves said that correspondences were exchanged by and between the parties. For cease and desist, they have given a reply. I am not going to cease and desist. Does anything remain thereafter of mediation? Nothing remains. The mediation would be, if it is relegated, if it had been relegated, the mediation would have been a farce. Because the parties have themselves been at loggerheads and they have given letters. The defendant has given replies and have said, I am not going to abide by it. I am going to continue. After that, where can a mediation or a settlement under 12A lie? It's not necessary at all. Then your lordship sees, my lord, the two judgments. One is, my lord, the, one is, my lord, the Bold Technology judgment, which is reported. My lord, it's a direct printout. It's a direct printout from the High Court, Delhi High Court website. And so I'll give the cost title to my learned friend. Lord, your lordship straightway, my lord, comes to, my lord, paragraph 14, where it distinguishes, my lord, Patil automation, where Patil automation had said that 12A was necessary.
Yes.
Your lordship sees 14. As to the manner in which section 12A of the Commercial Court Act would operate, the recent judgment of the Supreme Court in Patil automation has completely settled the legal position in this regard. The relevant observations of the Supreme Court in the said judgment are as under. In the cases before us, the suits do not contemplate urgent relief. Then it says, as to what should happen, it quotes. In suits which do not contemplate urgent relief, or rather the meaning of the word contemplate or urgent relief, we need not dwell upon it. Then, my lord, it quotes then lordship takes up paragraph 95. In the said case before the Supreme Court, the court has clearly observed that the suits therein did not contemplate urgent reliefs. Thus, the question that remains is as to the urgent interim relief that is being sought in the present case and whether exemption ought to be granted from going into pre-litigation mediation. The court will have to go into the question as to whether such urgent interim relief means only such relief which is sought due to immediate past events, or can it be urgent interim relief which the plaintiff seeks in the overall facts and circumstances of a particular case. Then he discusses, my lord, the importance of an interim injunction in intellectual property in Lakshmikant Patel, which I'll also place. Then, my lord, your lordship comes to paragraph 17. As per the experience seen in intellectual property cases, the relief of interim injunction, including at the ex parte stage and ad interim stage, is extremely important. Such matters do not merely involve the interest of the plaintiff and the defendants, which are called the contesting parties before the court, but also involve the interest of the customers and consumers of the products and services in question. Intellectual property cases relate to a wide gamut of business such as medicines, FMCG, food products, financial services such and such. Recent trends also point towards large-scale misuse on the internet. In some cases, due to the misuse, of known marks and brands, the consumers are being duped into parting with large sums of money. Now your lordship sees here, I just pause for a moment. Admittedly, they are using since 98. I am using this get-up since 2000, 2001. Nowhere in the appeal have they said since when they have been using this particular get-up. Nowhere. So when did they start this mark? They completely keep under hide and seek. Completely under wraps. They just don't disclose. When was it adopted? I have been using it since day one. Since 2000, 2001. And they continue to use different marks and thereafter come close to me. They don't disclose since when they are used. They are not registered of that mark, which they tried to portray. They are registered of something else, which is not the question of or issue on this suit. They are not registered of the label of the artistic work of under the Copyright Act also of this label. Now your lordship sees. So here, my lord, I just on facts I wanted to bring this one in. So the parties would be knowing, the consumers would be knowing my get-up prior to that of their get-up, which no one knows when it was adopted. So my consumers and other consumers know that this get-up is of the plaintiff. So everyone will be confused. The rights of the parties are affected almost on a daily basis as there is continuous manufacturing, selling and offering of services or goods to the customers. The ambit of urgent interim relief that may be required to be granted is extremely varied and depends on the facts of each case. Such reliefs are usually granted by courts not merely for protection of statutory and common law rights, but also in order to avoid confusion, deception, unfair and fraudulent practice. Now, my lord, your lordship marks this one. Unfair and fraudulent practice. This is what the defendant has done by adopting this get-up. In the marketplace. 18. It is also the settled legal position that delay by itself does not disentitle a plaintiff to the grant of interim relief. The position of law was reiterated in Midas, and it quotes, my lord, paragraph 5. The grant of injunction also becomes necessary if it prima facie appears that the adoption of the mark was itself dishonest. The Supreme Court says this. So on the face of it, the dishonest adoption of the get-up is fraudulent and dishonest. Of this get-up particularly. Then, my lord, your lordship, my lord, straightway come to, my lord, paragraph 19, and it quotes, my lord, one of another Supreme Court cases. It quotes the same one. Then your lordship, my lord, comes straightway, my lord, to paragraph 20. Paragraph 20. 22, man. That would be better. 20 is not. Or I'll just rely on it. On facts, my lord, not necessary, comes to 22 on principles. The above, now your lordship sees, there was a legal notice given. The above legal notice dated 24th May 2022 was served upon the defendants both by speed post, courier and email. The defendants did not reply, leading to a reminder to the said legal notice being sent by the plaintiff. Finally, a reply by the defendants was issued on 5th June, which was received by the plaintiff on 9th June. In the said reply, the defendant clearly took a stand that it is entitled to use the mark bold for various reasons as set out in the said reply. Here also, my lord, is the same thing. They said, no, I've got the right to use because of swastik and arrow. The concluding paragraph of the reply dated 5th June 2022 is highly indicative of the defendant's intent and reaches under. Here also they have said, no, I'm not going to. That's an admitted position. Now, my lord, paragraph 23. In the opinion of this court, the above reply to the legal notice clearly violates the letter and spirit of section 12A of the Commercial Courts Act, which was introduced with the intent to encourage mediation as discussed herein above. It is notable that while the plaintiff suggests an amicable resolution of the dispute, the defendant sought to term the legal notice as frivolous notice. The defendants also claimed that they were being harassed without verification of facts. The ultimate icing was that the demand to the compensation of 5 crore along with legal costs from the plaintiff. So, my lord, if now your lordship sees what the reply of the defendant has been to my notice, kindly sees one or two paragraphs, sufficient for it. Kindly comes to the stay application. Later on. Yes. My lord, page 189. He comes to paragraph 1. At the outset, we say that save what are matters of record and save what have been specifically admitted by our client, each and every allegation of contention contained in the said notice is denied as if the same were set out such and such. However, anything not specific, then paragraph 2. It appears from the contents of the said notice that either you have been improperly instructed or your client has deliberately failed to acknowledge the actual facts and figures of some of which is delineated hereinafter. It is material to state, then they go on to state the facts that swastik is registered, all sorts of all those things. And then your lordship comes to straightway, it's a longish reply. It's illegible. Then your lordship straightway comes to 1. Yes, paragraph 19. He says that they are entitled to use it. They are prior user and registered. Again, they say, Malad, the registered prior user of the mark swastik. I'm not on swastik and cannot be restrained from using the same, having been extensively and such. Our client has been using the trade, kindly see now, the middle of that paragraph. Our client has been using the said trade dress as sought to be impugned in the said notice much earlier in point of time than the trade dress as sought to be used by your client. No dates disclosed in the appeal. No dates disclosed in the reply. A bold statement. Then your lordship sees, your client is notified, is not entitled to claim any relief, inter alia, damages or costs as against our client by way of any legal proceedings or otherwise, and the claims as sought to be advanced by your client are false, fabricated, confounded, and are denied and disputed. In view of what has been stated above, there cannot be any question of our client complying with any of the demands of your client, which are illegal and baseless and are denied and disputed. Our client is the proprietor in view of our client's uninterrupted and unfettered use, such and such. the same as acquired extensive, then they go on to say these things. And then, my lord, paragraph 20, we repeat and reiterate that your client does not have any valid cause of action to proceed against our client, and our client reserves its right to defend itself in any proceeding, howsoever frivolous, that your client may initiate against our client. We call upon you and your client, kindly mark this. We call upon you and your client to forthwith recall, rescind, and revoke the said notice dated such and such, and the allegations contained therein, and also request you and your client not to proceed with any frivolous action. Such
Okay,
and such.
okay. So your submission is that this 12A is not required to be complied with.
12A dispensation becomes almost a matter of course now, after their refusal, and in view of the judgment of the Delhi High Court.
Okay. Any other point?
One more point, my lord, which they have stated, that is with regard to, and my lord, one judgment of the Supreme Court where the 12A they have said should be complied with only on the basis of if there are suppressions to artfully get around it, and there are suppressions of material facts which would show delay, and 12A the dispensation of a 12A dispensation should not be granted.
Okay,
that is on the suppression. Okay. So here there is no suppression at any material point of time.
Okay.
And my lord, our copyright registration, which is at page 89 of the stay application, which is annexed to my petition, which is there in my order 39 rule 1 and 2 petition. Kindly comes to page 89. This is my registration. The get up which I am carrying on, against which is the cause of action of the suit, is registered under the Copyright Act. Your lordship kindly comes to column number 8, column number 9, and kindly see year and country of the first publication is 2001. On the basis of which use I have claimed, the Copyright Office has granted me registration of this get-up. So this get-up I am entitled to protect against anyone, even the defendant. These are all on merits. These are all on merits, which needs to be, my lord, adjudicated before the trial court. What is their pleading in the appeal to show that the interim order granted by the learned commercial court was erroneous on the face of it, and on the documents and pleadings disclosed by the plaintiff on oath in the plaintiff? But I won't go into the merits of the case, because in the appeal court, perhaps, my lord, superseding, my lord, the adjudication of the commercial court, my lord, without any documents being in front of them, my lord, perhaps that should not be done, my lord, at this stage. It's an appeal. They have taken the risk of coming up in appeal against an ad interim ex parte order without showing in the appeal, or failing to show in the appeal, that there has been suppression of material facts, number one, and number two, that the learned judge has erred in law while comparing the two labels which are used, the trade dresses which are used. These are the two trade dresses which I had shown it to your lordship physically today. The learned judge compared these two trade dresses and granted an order of an injunction restraining them from using that particular trade dress, not anything else. The learned trial judge did not restrain him from using swastik logo, from using any parts. He can use it in any manner he wants, in any format he wants, in any style he wants. But he cannot adopt an identical style which is registered by in favor of the plaintiff. And second, thirdly, my lord, a very peculiar thing, which is, my lord, very, very extremely necessary in an intellectual property matter for the defendant to explain why they have adopted this style. This particular style. Nowhere in the appeal they have said why they have adopted this style. From which good Lord they have got this message that yes, they can adopt this style and use it for their benefit in the market. Well, these are my submissions. Well, perhaps I don't think I need to show further judgments on this. Well, in my humble submission, well, the order of stay needs to be set aside because the impugned order of injunction does not restrain them from carrying on business under the several marks which I have shown in Annexure P2, which they have, other than the one which I am aggrieved with. If there is no injury or prejudice caused to them if they carry on with their business under those labels and packagings, other than the one which is impugned. And secondly, Miller, without the commercial court or without taking their opportunity or chance before the commercial court on merits, the order cannot be set aside on merits in the appeal from an ex parte order of an injunction when there is no suppression.
Okay.
These are my submissions.
So you want to reply on a different day?
My lord, 25.
Okay. Heard Mr. G. and Sayola, learned new counsel assisted by Mr. Sayola, learned counsel for
Appellant.
petitioner, and stroke appellant, and also heard Mr.
So, my lord, Shayantan Basu.
Shayanta Basu. Senior counsel,
Senior.
learned senior counsel assisted by Mr.
How much Kashyap?
Learned counsel for the respondent. Struck. No.
How much Kashyap?
Okay, respondent. Heard in court, list the matter for further hearing on
Also, the first week of May, Lord.
first week of May.
First week of May, 23rd.
April.
Because not the appeal, this.
No. 23rd April.
Because the injunction order has been stayed and they are carrying on merrily with
No,
their.
can we not dispose of both the matter together?
Yes. The appeal and the stay can be
Yes.
disposed of.
Yes.
Because we have argued extensively and nothing is there on merits to be argued, in fact.
Yes.
So on the these 3 points, it can be disposed of. Yes.
So 23rd will be
Anyway, my lord, I have nothing to say. You can-
okay. 23rd. As part of
Interim may continue, my lord.
pardon?
Interim may continue.
Till then, interim order pass earlier shall continue.
Much obliged.
Number 20.
May I please, your lordship?
Yes.
Lordship, this IA is for a condemnation of a delay of 471 days, so a notice may be issued at this time.
Heard Mr. Discuss learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condemnation of delay of 471 days in preparing a revision petition. Here is the petition under documents placed on record. Let notice be issued to the respondents returnable in quarrels that be taken by registered post with AD and also by usual process. We can have quick note to that. List the matter after 4 weeks.
Highly observed.
31.
May I please, your lordship? Lordship, 137 days delay, your lordship, to prefer an appeal under section 20, matrimonial appeal under section 28 of the Hindu Marriage Act, your lordship. Now, your lordship, the reason.
For the applicant, this application under section 5 of the limitation act is prepared by the applicant for confirmation of delay of 137 days in preparing matrimonial appeal against the order dated 17/8/2024 passed by the Court of Learned District Judge, Locking-Ford, North Locking-Ford. There is the petition and the documents plus on record. Also, there is the Indian order dated 17/8/2024. Let notice be issued to the respondents, returnable in 4 weeks, step be taken by the third post with AD and also by usual process within a return to them. Place the matter after 4 weeks.
22.
Lordship, the petition under section 5, Lordship, 27 days delay, Lordship.
27 days. Okay. Heard Mr. Chakraborty,
Lordship.
Learned Counsel for the applicant. This application under section 5 of the limitation act is prepared by the applicant. Under order 41, rule 3A for condonation of delay of 27 days in preparing an appeal against the judgment and decree dated 5/11/2024 passed by the Learned Civil Judge, Senior Division, Gulagat in PS number 2 of 2014. Where is the documents plus on record? Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by the process within a week from the rest of the 4 weeks.
23.
May please be, Lordship, this condolence of delay petition is the first time, Lordship. So notice may kindly be issued, Lordship.
Heard Mr. A.R. Agarwala, Learned Counsel for the applicant. This application under section 5 of the limitation act is prepared by the applicant for confirmation of delay of 19 days in preparing appeal against the judgment and award dated 12/10/12/2024 passed by the Learned member, motor accident claims tribunal number 3, Kamrup and Guwahati in MSC case number 720 of 2022. First, the petition and the documents. Enclosed therewith, let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual post. Anyway, come to the
Lordship,
list of the 4 weeks.
Lordship, I missed item number 16, Lordship, for admission, Lordship, MSC appeal, if we may
No.
kindly consider.
Once it is a poll.
24.
May I please, your lordship? I is for condonation of delay of 17 days, lordship. Notice may be issued.
Pardon me, sir.
R. Sharma.
R. Sharma, Learned Counsel for the applicant. This application under section 5 of the limitation act is prepared by the applicant for condonation of delay of 17 days in preparing an appeal against the judgment and award dated 3/7/2024 passed by the Learned member, Motor Accident Claims Tribunal, Barpeta in MSC case number 464 of 2014. Is it 14 or 24?
14, lordship.
14.
Lordship.
Then what is the delay? How 17 days delay?
Lordship, a judgment was passed on 3/7/2024, lordship.
24.
24.
Acha. Let notice be issued to the respondents, returnable in forest that be taken by registered post with AD and also by usual process within a week. List of the forest.
Apply, lordship.
25.
My limitation is barred by 16 days, my lord. Notice to my.
Heard Ms. L. Sarma, Learned Counsel for the applicant. This application under section 5 of the limitation act is prepared by the applicant for condonation of delay of 16 days in preparing an appeal against the judgment and award dated 29/11/2024 passed by the Learned member,
Chirang.
Motor Accident Claim Tribunal, Chirang, Kazalgaon in MSC case number 2 of 2024. First, the application and the documents placed on record. The notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today, and it's about 4 weeks.
Obligation.
26.
This is the condolence of delay petition, Lordship, first time, Lordship. So notice may kindly be issued, Lordship.
Heard Mr. A.R. Agarwala, Learned Counsel for the applicant. This application under section 5 of the limitation act is preferred by the applicant for condonation of delay of 154 days in preparing MSC appeal against the judgment and award dated 16/7/2024, passed by the Morning Member. Auto accident claims tribunal, Golpara, University case number 102 of 2019. Where is the application and the documents placed on the record? Let notice be issued to the respondents returnable in 4 weeks. To be taken by registered post with AD and also by the process. It's the 4 weeks.
Item 32.
But in this case, Lord, a decree was passed in my favor for execution of a sale deed, and that decree was reversed in the appellate court. Thereafter, we preferred this appeal. Now, during the pendency of this appeal, at one point of time, the respondent tried to fill up the earth in the suit land, and we approached before this honorable court by filing an application under Order 39 Rule 1 and 2. And Lord, your lordship to find that order at page 25. Well, even page 27. Let us start from page 26. Heard such and such learned counsel for appearing on behalf of the appellant petitioner. Also heard as the learned counsel appearing
The
on.
other day, on the other day, you have shown this order to me.
Yes, Lord. Now, on the other day, my learned friend was not prepared.
But today the counsel is absent.
Yeah, he is also absent. On that day also he absented.
Who is the counsel?
Mr. T. Rai, no?
T. Roy.
Upon.
T. Roy. Don't take number, sir.
Public person.
Yeah, wait for some time. The court master will contact the council. Wait for some time.
All right.
33.
Yeah, please, your lordship. I is for release of 50% amount deposited by the insurance company, my lord. Order is at page, my lord. 12.
Yes, any objection?
No, you're not. I have no objection.
Mr. Jaisarma, learned counsel for the applicant. This interlocutory application is prepared by the applicant for allowing the applicant to withdraw the sum of rupees 30,701 deposited before the registry of this court, being the 50% of awarded amount pursuant to order of this court dated 12/2/2025, passed in MSC appeal number 550/2024. The learned counsel for the opposite party, Ms. P. Portakur, submits that she has no objection in the event of allowing the applicants to withdraw the deposited amount, 50% of the awarded amount, which was deposited before the registry of this court. Para taking note of the submission of learned counsel for both the parties, the applicants are allowed to withdraw the amount of rupees 31 lakhs 30,701 being deposited before the registry of this court. Pursuant to order dated 12/2/2025, passing MSA appeal number 550/2024. In terms of this, I expose.
Obliged. Standing item 3, promotion.
May it please your lordship. Here is a dispute between landlord and tenant lordship that lordship may kindly turn to page 11, that is the plaint, and relevant portion I am referring to is page 12, paragraph 4, lordship. So my specific case was that he was not he was not paying the rent and also illegally depositing the rent before the court. Now thereafter also I filed an application for because he said that he has deposited the amount in the court. So I filed an application before the trial court to call for the NJ case records, lordship. And accordingly, my prayer was rejected. That interim order your lordship will find page 34. Mainly on the ground, your lordship will find page 36, that part. Mainly on the ground that no specific records were mentioned in the petition, but in my case was that, lordship. While the solicitor was deposing before the court, he submitted that he found some NJ cases which were lying in the office, lordship. And accordingly, lordship, we have said that our application, your lordship will find at prayer portion at page 29. And it starts from page 28. Page 29, lordship may kindly say paragraph 3 and prayer portion. In paragraph 3 also, we have stated why those are required, lordship. Because our specific case is that he never approached us, lordship, for giving the rent. If we refuse to accept the rent, then only he can deposit the amount in the court, lordship. That refusal by the landlord, that is the main thing, lordship, in the present case. That your lordship can in paragraph 3. That purpose and prayer also I have made that it is therefore prayed that court be pleased to direct the solicitor of civil justice produce the register book of NJ cases and the NJ cases between the parties which have been traced out by him at his office in the court at the time of adducing his evidence. So on last occasion also I have placed before your lordship, and your lordship wanted to see the statement of the Sirastadar. So accordingly I have filed one additional affidavit, lordship, to bring on record.
It is recorded in the order evidence of series column.
Lordship.
I could not follow. What is this? I have, of course, put my signature there. Evidence of sister.
Lordship.
Should have been.
Lordship. I have filed an additional affidavit.
Enclosing the evidence of the sister.
Lordship. At running page 42, your lordship will find.
Pardon?
Page 42 is the original copy, lordship. Xerox copy of the certified. And typed copy is at page 40.
No, those NJ cases were produced before the court.
Those were brought because initially, lordship, the defendants filed the application for calling for those records. Subsequently, it was the solicitor submitted, lordship, that some of the case records are missing.
Could not be traced out.
Could not be traced out. So subsequently, when he came for deposing, he said that I have found some of the cases, lordship, of that NJ cases. So accordingly, we filed an application to exhibit those records, lordship, and the case records. And the trial court held that those records are not necessary. But my submission to your lordship is that Urban Area Rent Control Act Section 5, subclause 4 says, lordship, if the landlord refuses to accept the rent,
only then he can deposit
yes,
the
lordship, that
amount
is
in the court.
Yes, and that can be ascertained only from the NJ case records, not from the challan. Because in the petition, they have to state that I offered the rent to the landlord, he refused. Whether those things are there in the records or not, only for that purpose, I want to exhibit the NJ case records. And therefore, I have in, in my petition also in paragraph 3, I have stated. And in my plaint also, that is my case, that he never
Approach you.
he illegally depositing the rent in the court. And if that is that I can prove, Lordship, then I have case, Lordship. Otherwise, I will not have case. And that is the mandatory, Lordship, is from the statute itself. And even then, Lordship, I am just relying on our.
No, not necessary.
Lordship. Because it is the burden of the plaintiff in his own case.
Heard Mr. Ahmed, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 8/11/2024, passed by the learned civil judge, Junior Division number 1, Shivsagar at Shivsagar. Passed in PS number 156 of 2006. This to be noted here that by impugn order dated so and so, the learned trial court has dismissed the petition number 749/2024 filed by the petitioner herein to call for the NJ case records by which the respondent herein has deposited the rent before the court. Mr. Ahmed, learned counsel for the petitioner, submits that the pleaded case of the petitioner is that without approaching the petitioner first, the respondent herein has deposited the amount before the court, before the learned court. And to establish the said plea, to substantiate the said plea, calling for the record of the NJ cases by which the respondent herein has deposited the rent before the court are very much necessary. And therefore, Mr. Ahmed has contended to allow this petition. Having heard the submission of Mr. Ahmed, learned counsel for the petitioner, I have doubly gone to the petition and the documents lesson record and also here's the impugn order dated 8/11/2024. In view of the submission so advanced, no, in view of the stand so taken by the petitioner in the title suit number, in the title suit number 156 of 2006, and also in view of the submission of Mr. Ahmed, learned counsel for the petitioner, this court is of the view that the NJ case, the record of NJ cases by which the respondent herein has deposited the rent before the court is very much necessary to substantiate the stance so taken by the petitioner in his pleadings. In that view of the matter, the impugned order appears to be arbitrary and illegal, and therefore the same stance set aside and cost. The learned trial court is directed to call for the NJ case records from the office of the
Sirastadar, Lordship.
no, from the office of the
Sirastadar of Civil Judge,
the
Junior.
of civil judge,
Junior 1, JR
Junior Division 1.
Chipsagar.
Ipsagar, in terms of this CRP, I was done, dispose of it. Small on the side.
Obliged, Lordship.
Timing 32.
Oh,
No, we like to contact Mr. Tapan Rai. We could not contact him, but we contact his wife. He is also an advocate. She is also an advocate. Now, according to her version, the file has been taken away. Probably the brief was entrusted with B.R. Day, senior counsel. He expired. And one of his junior, what is his name?
Soumitra De
And Pranay Rai. Pranay Rai is also expired. Pranay Rai also expired. And Soumitra De, he was practicing in Guwahati High Court. Now he is staying at Kachar. Probably this is the problem. On that day, he received the copy from us, but otherwise he should have come to the court and tell it the facts.
so, can we list it on the very first day of opening?
All right, Your Lordship, can, in the meantime, status quo as on date, till date. We tried to contact him. We contacted his wife.
She is also in this case.
Probably the brief was entrusted with Mr. B.R. De, senior advocate. He expired, and this Tapan Rai and Mr. They are the junior. And I am under impression that this file might have been taken from them. But till then, Millard, something has to be done.
The problem is that this is second appeal.
Your Lordship can fix the date of hearing. No? You can argue this matter. No problem.
Finally.
Finally, you can fix it, date for final hearing. But the council should come, no? That is the problem. Your Lordship can fix the date of hearing. Though the paper book has not been prepared, but the case is in a very narrow compass.
No, that's all right. But whether paper book is required to be prepared?
I don't think paper book is required. If the local judges hear this matter,
then we finally hear and dispose of the matter
and
after vacation.
Yes, that can be done. Until date, some types of relief, at least status quo was on that day. Your Lordship fix the date of hearing immediately after vacation. Without paper book, dispensing with the paper book. Otherwise, the matter will get delayed. The paper book has to be constituted. Only 2 witnesses. Plaintiff number 1, PW1, DW1 and 2. 3 witnesses. These are in particular. And if the local just take up the matter, then it can be concluded. But these first appeal and second appeal matters are generally taken up by the local judges.
So, you have lost on a police case also.
Yes, we lost the police case.
Thereafter?
Yes, as because they are failing art, Millard.
No. Whether any action was initiated.
No action was taken. Because these are civil dispute matter, generally police does not enter into this matter.
So, what is the background of the case? The suit was
decreed in my favor.
By both the court below.
No, but the
Trial court.
Trial court, and then
Trial court decreed the suit in your favor.
Yeah.
And the appellate
Then
court
it
has reversed it.
reversed it, and we preferred a civil suit. Second appeal.
Whether any injunction was granted by the trial court at the time of pendency of the suit.
That I can't say.
Pardon?
That I can't say, Miller. Whether an injunction was granted or not.
No, you may go through the record and point it out.
But it was reversed, no, even it was reversed. That decree which was
Reversed by the
granted in my
appellate court?
favor, that was reversed. So that injunction order will not help us. Because it's a reversal of the decree, Millard. কি করা হবে? Date of the fixed করে অনেকে। Your lordship fix a date of hearing. In the meantime, Lord, let us try. Otherwise, Lord, date of hearing may kindly be fixed. But same thing will happen.
Again, the council will remain absent.
Remain absent because today we have contacted his wife. He is also an advocate. Or a notice can be issued to them.
So, on one occasion, Mr. Mahmood appeared.
Yes, Mahmood appeared.
He is not present in the court today.
No, not he is present in the court. I have been engaged subsequently.
Oh.
Now, Mahmood is in my favor.
Okay. Oh, he was
Taken
for
it.
the appellate. Okay.
He is also appellant, I am also appellant.
So S. Sandra was there for respondent.
Yes.
S. Sandra.
S.
You have
Sandra.
contacted S. Sandra.
No, Tapon Rai. His wife, Tapon Rai's wife, Mr. Q, what is his name? B. Sarkar. She is not in this case. She is also in this. She's also in the case.
this
one. But in the,
Her name is here in the lawsuit.
She is not in this
Her,
case.
her name is in the law, in the cause list. Bishop.
Bishop Asan Inam? Huh? Oh, then we contact her today. Though his name has not been reflected in the cause list. Bishop Asan.
So let us fix a date for final hearing. Then in the meantime, you try to contact the council. Then court master will also try to contact.
And your lordship may not dispose of this appeal.
Yes.
Let it be kept alive.
Yes, yes.
All right.
Heard Mr. Dasgupta, learned senior counsel, assisted by Mr. A. Das. Learned counsel for the applicant, stroke appellant. List the matter. Okay.
Date may kindly fix. Otherwise, we are in trouble.
29th of April. For hearing.
Item 27 and 28. Hearing fixed at
The lordship may kindly issue notice to the injunction petitioner in the meantime. Allah, let it be good. Very good. I'm not time.
Lordship,
yes, that's it.
One thing that my friend advised me, let us issue notice to the respondent. We shall take steps. We will go to them.
Notice to the respondent.
Respondent.
Let notice be issued to the respondents or returnable in 4 weeks then.
Yes.
Step be taken by registered post with within also the usual process within a week. List the matter and then 4 weeks.
By making some observation, the council has not appeared before this court. Otherwise, when the matter was called upon, the council was not present. In view of this factor, notice may be issued to the respondent.
As none appears for the respondents opposite party
on 2 occasions.
On 2 occasions, so let notice be issued to the respondent. Okay. Yes.
Lordship, that resolution part that.
Yes.
I have just placed it. This is that second page is that copy, which has been, this was approved on 7/10/2020, and the remaining part is that memorandum. That is an abstract. It was approved
No,
on,
that approved, all right. Thereafter, whether any order has been passed in the name of the governor.
no order as such, lordship, because this,
No, this as per this rule of executive business.
lordship.
So one order has to be
Issued,
issued by the secretary of the concerned department in the name of the governor.
Lordship. To that extent, lordship, I have not come across, because the one which I have
No,
asked.
that is the way of
Lordship,
implementing the decision of the
executive
cabinet.
business, lordship. Here there is an approval, and otherwise this was. And the other one is the lordship directed to produce that list 1 and list 2 that I have given. List 1 and list 2. Up to that yellow flag, lordship, list 1, and after this yellow flag onwards, is the list 2. List 2 is the untrained, and list 1 is the trained pitchers.
So the name of the petitioners are in which list?
Lordship, here the name of the petitioner, those in respect of the petition number 2017, those 3 petitioners were accommodated, and their name appears in list 1. List 1. Serial number, petitioner number 7 is at serial number 137. Mohendra Gogoi is the petitioner number 7. His name appears in the list 1. And petitioner number 10, lordship, appears in serial number 419. Mohendra Gogoi. And petition number 14 is 428. The same page. Serial number. Petition number W 6435. According to our it is affidavit, lordship. These 3 features.
So whether there's a list as a part of the main record? No.
We have today
Yeah,
only
please,
came to know about
furnish
this.
a copy to him.
Lordship, I have a soft copy.
Let
because
him
it's
go
a
through
bulk
it.
one. Otherwise, my learned friend will get
And on the next day, you point out the name of the petitioners in the list.
Only 3 petitioners are there. They have got the new appointment. Only 3 petitioners.
Three
We have not
petitioners, they have
denied
been accommodated as teacher.
No, other
Others, lordship, they have not been, because in the meantime, 2 petitioners attain the age of superannuation. So that has been clarified in our affidavit, lordship. So petitioner number 645. Petition number 3, 7, and 10. No, sorry, I'm sorry. 7, 10, and 14. These 3 petitioners has been accommodated as teacher because they fulfill the criteria and they have been accommodated as teacher. Their name appears in list 1. In serial number 137, 419, and 420 respectively. And rest of the
Since
teachers,
they have been accommodated, whether you have any pair in respect of them in this petition now?
This petition was filed in 2017, Your Lordship. Subsequently, we have not made any petition. Under compelling situation, we have been compelled to join this due to the starvation.
My question is, are you?
No, not
Since
filed.
they have been accommodated, are you pursuing this petition now?
For arrears and other matters, they will be, this petition will valid because they have worked till their appointment on earlier service. So they will obviously receive those salaries till they work in the earlier post. So it is their right.
But lordship, these accommodations were made with the prospective effect. With the terms and conditions that no area, because it is a one-time measure taken by the cabinet lordship. Therefore, there is no retrospective effect. This accommodation has been made with prospective effect, and the terms and conditions having been accepted by the petitioner, they have joined their respective issues. So no claim for areas.
Whether those acceptance,
That
the documents are part of the record.
No, lordship, that is not there.
Then-
It was, affidavit was filed, but those accommodation and acceptance letters are not here, lordship.
Then
It is not part of the record, otherwise they have been accommodated and they have joined.
no, that's all right. If they have signed any bond not to claim the past salaries.
Lordship, in that case, lordship, that will also be necessary.
Yeah. Otherwise, you have no objection in allowing the petition,
Lordship.
in giving their past salaries.
No, lordship.
No,
No, we have objection because.
you have
this-
objection.
Lordship, we have
That's
objection.
all right.
because
And
if-
if that is your stand, you produce those documents that they have given this bond
Lordship.
or undertaking that they will not claim such a.
Lordship, because the letter of accommodation, the order of accommodation itself clarifies. There is a clause 6 in the, I'm sorry, today I cannot produce lordship, but otherwise, there is a clause 6 where it has been specifically stated that this order of accommodation is made with prospective effect.
That's all right. Whether they have given any undertaking.
Lordship, to that extent, lordship, again, I have to.
Obtain instruction.
Lordship, whether they have accepted joined or not, lordship, because they have joined, that is implied, but that acceptance letter and all, lordship.
In compelling situation, they have joined it because they have not getting salary or otherwise. Government has given some new opportunities. They have no other way but to join this. So, but merely signing the bond, their right will not be get away.
Okay,
Because
we'll see. But you saw from your affidavit where you have taken such a stand.
Lordship. Joined and lordship.
Yes.
Our affidavit, lordship, may kindly peruse
Page number.
175 onwards, lordship.
In
That
which
answering
paragraph it
respondent,
is stated.
the answering respondent humbly begs to state that out of 14 petitioners, paragraph number 30, lordship, I am reading.
13.
Lordship, page number 175.
Sir, in your affidavit, you have mentioned about 3 lists, but you have produced 2 lists only. What about the third list?
Lordship, third list is of those teachers, lordship.
Who have neither received salaries nor qualified in
Lordship.
training.
Lordship. Because lordship directed to produce these 2 lists. Those
Where
who
is
are-
that list?
Lordship.
Where is that list? List three.
List 3, lordship. Because list 1 and list 2, they were those who were accommodated as teacher and those who were accommodated as tutor. List 3 also I will produce, lordship. In fact, on the next occasion. This list has been provided for the district of Shivsagar, lordship.
That's all right.
Lordship. Then in that case, lordship, let me produce that list 3 also in respect of.
Now you show me from which paragraph you have mentioned it.
174.
Serial number, paragraph number.
Paragraph number, lordship. I'm sorry, 175, paragraph number 13. That the answering respondent humbly begs to state that out of the 14 petitioners, 3 numbers of petitioners, namely so and so petitioner of 7, so and so petitioner number 10, and so petitioner number 14 have been appointed as newly accommodated teacher with prospective effect on the basis of the cabinet approval dated 7/10/2020. I have placed before lordship. In respect of in respect of Sri Mahendranath Mahendra, petition number 1 and Sri Chittaranjan Bargohai, petition number 2, though they participated in the screening process and fulfilled the criteria as laid down in the cabinet memorandum and identified as irregular teacher, however, they could not be appointed as newly accommodated teacher since in the meantime they had attained the age of superannuation on 30/4/2020 and 31/5/2019. So these two petitioners, they could not be accommodated, having been attained the age of superannuation. Now for the remaining petitioners, lordship, paragraph number 14. That the answering respondent humbly begs to state that the remaining petitioners, petition number 3, 4, rest of the petitioners, lordship, so and so, so and so, so and so, petition number 13, did not participate in the said screening process. And therefore, they could not be accommodated in any of the post of tutor or teacher under illegal or irregular teacher category. The claim of the petitioners for the payment of salary is rejected since their initial appointments were illegal. Because their initial appointments were illegal, as there was no any due process were followed, lordship, and their appointment were in the excess post, lordship. So therefore, this is the status. Number 15 is also important, lordship, and answering humbly begs.
And their names are in the list 3 and you have not produced the list 3 before the court.
Lordship, in fact, on the last one, is in list 1 and list 2.
No.
Lordship, I
Mr.
will.
Sharma, you see, it is your averment in your pleading.
Lordship.
That there are 3 lists.
Lordship. In that case, lordship, I will produce the list 3 as well as that, lordship, that these undertakings of 3 petitioners. Lordship may fix after vacation, lordship.
Okay, your lordship, the matter may be remain as part heard. Otherwise, it will again have to.
Okay, you please go through the list. You will forward it to you.
Okay.
Heard, Mr.
H.C. Sharma.
H.C. Sharma, learned for the petitioner, and Mr. E.N. Sharma, learned standing counsel for the elementary education department, and Mr. Toliha for finance department. Finance department. Person to order of this court dated 8/4/2025. Mr. Sharma has produced 2 lists. List 1, list 2 before this court. But it appears from the averment made in the paragraph number 13 of the affidavit in opposition filed by the respondents in elementary education department that there is another list. That is list 3. And the said list is not produced before this court. And some of the petitioners herein, the names of some of the petitioner herein find mention in the list 3, and as such, perusal of the list 3 is found to be necessary here in this case, and accordingly it is provided that Mr. Sharma shall produce the list 3 before this court on next date. So regarding the undertaking, you have not mentioned anything in your averment. In your pleadings, in your affidavit in opposition.
Lordship.
So will not direct you, but you may produce it.
Lordship.
Copy of the
Listed
list.
on
8 May.
অলপ সোনকালে কৰি দিওঁ নোৱাৰে নেকি এপ্ৰিল মাহতে
April 1st May.
ফাৰ্ষ্ট মে হলিডে নাথাকে ন
No, open.
apply যায় sir it directed to be served the copies of list
Mr. Sharma shall furnish the list of list 1 and list 2 to Mr. Sharma, learned counsel for the petition.
Lordship.
During the course of the day,
Lordship.
you will furnish the soft copy to him.
I will furnish soft copy.
part heard বুলি মানে apply যায়
Item number 8 as last item.
Please, Your Lordship. Before delving into the merit of the case, Lordship, I would like to state that there is some typographical error in the cause title, Lordship, as well as in the affidavit part, Lordship. So I may be allowed to correct it, Lordship.
Okay, then after vacation.
Lordship.
Lordship, kindly fix a date, Lord. After vacation. The motion
Or-
item,
or-
original
or
cases of
Mustaq, learned counsel for the GRM Mustaq, learned counsel for the petitioner, and Mr. R. Ali for the respondent. This caveat is there. Caveat would be heard. Caveat is research. The learned counsel for the petitioner submits that some typographical mistake occurred in the cause title of the petition, and as such, he prays for granting him some time to make necessary correction of the same.
As well as in the affidavit, Lordship. As well as in the affidavit also.
In the cause title of the petition, and also in the affidavit filed in support of the same. Care is accordingly allowed. SSL is the matter immediately after reopening of the vacancy.
Lord, today is time short, my lord. Here in this case, section 47 petition was rejected, my lord. So at this stage, notice may be issued, my lord. Because
We will definitely issue notice, but the thing is that you have filed the petition under section 47
yes,
to examine the executing court to
executability of the,
yes, to examine the issue of executability of the decree.
yes, that I am showing, my lord. Why? The decree was, there was a.
No, the question is whether the executing court can go behind the decree.
No, not behind that. That is the my case. It cannot go behind the decree. Page 38, what was the decree? Decree was they want declaration of right title interest over first schedule land and recovery of schedule, second schedule and third schedule. But when the decree was passed, and apart from that, there was other prayer that my name may be deleted from the muted record of rights, all these things that were not granted. Only granted is by specific mention 10 katha, 8 chatak land be recovered. But in the schedule B, there are 3 katha and schedule third schedule 9 katha, 12 katha total. And my name was there in the mutation land record. So only with respect to the decree of 10 katha 8 lesa, they are entitled. Now they are trying to evict from schedule second schedule and third schedule.
No, that is as per the decree.
No, kindly see the decree. That is why, my lord, kindly see
No,
the decree.
you have become unsuccessful in the second appeal also.
Yes, page 38. Kindly see what was the decree. Decree. Page 38. A declaration, field mutation. This is the prayer. Kindly see. Declaration, field mutation made in so and so of Southernmanship, so and so are within the, is invalid, ineffective, and liable to be cancelled. A demarcation of the boundary of the first schedule suit land, conducting the local survey by appointing Amin Commissioner. For demarcation that plaintiffs are entitled to have right title interest and possession over below mentioned first schedule land, for getting khas possession by the plaintiff over below mentioned second and third schedule land. Kindly see what is this second and third schedule. Next page. Second schedule is 3 katha. Lordship got it. And third schedule is 9 katha. Lordship got it. Now kindly what was decree has been passed. Page 40. It is ordered that suit is partly decreed on contest with cost against the defendant declaring plaintiff right title interest over first schedule land. Plaintiff are entitled to get recovery of khas possession of second and third schedule land measuring 10 katha 10 chatak. So they are only entitled for executable decree is with respect to 10 katha 10 lesa. Now they are trying to execute the schedule B and second schedule and third schedule, which contains 12 katha. And other prayer, mutation prayer and other prayer, it was not granted. Regarding deletion of my name, regarding correction, all this thing was not granted. So in the name of this decree, my lord, they want to evict me from the entire second and third schedule. But entire second and third schedule was not decreed. This is only my case.
Pardon, Mr. S.K. Ghosh, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with section 115 and 151 CPC, the petitioner has put to silence the correctness or otherwise of the order dated 4/1/2025. Passed by the learned civil, the senior division Hailakani in Mizia case number 117 of 2022, arising out of title execution case number 15 of 2006. Is to be noted here that by the impugn order dated so the learned executing court has dismissed the petition filed by the petitioner under section 71, read with section 47, read with section 151 of the Code of Civil Procedure. Whereas the petition and the documents placed on record and also whereas the order dated 4/1/2025. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with ADN also by usual process within a week from today. Within 2 working days from today. Less the matter after 4 weeks.
No, only some prayer that executing court may not go beyond the decree. That observation.
No, that observation itself in the order.
No, but the executing court, B and C, not B, second schedule and third schedule, that is 12 katha they are want to take. But decree was 10 katha, 8 shata. This is so decree specific. There was a specific degree 10 katha, 8 shata. In the boundary also, in the boundary mention I have not shown. In my land is there.
Okay, it is made clear that pendency of this petition would not be a bar for the learned executing court to executing the decree strictly in accordance with the
decree
passed in the title suit.
Title suit
number?
Title suit number. No, I'm giving. Title suit 9 of 1999 with respect to 10 kata 8 chata.
I will not mention anything.
No, it is mentioned in the decree also. In all the court, it is mentioned.
I am strictly in accordance with the decree.
Strictly in accordance with the decree, yes. Much obliged.
One more is there.
Sorry, my lord. Actually,
No problem. Also, this yesterday's matter, you make necessary correction. Huh?
I will do actually certificate is to be given after memo.
Oh, yes.
Only certificate part. Only certificate. Actually, in earlier occasion, in all occasions, we are doing like this way.
But I am not accepting it since I am taking up the bench. So I have to treat all of you in equal manner.
Equal manner.
Therefore.
That is why I will file memo. Correct.
Yes, Lordship, here I have come for challenging the interim injunction order, that is page 42, Lordship.
The scan copy has not been received.
Lordship, office note dated 9/4/25. Scan copy has not received.
Can we hear the matter without scan copy of
No,
the record?
Lordship. Scan copy is required, Lordship.
Required.
Lordship, otherwise, prima facie, Lordship, this order itself is illegal, Lordship. From the face of
That's
the
all right,
order.
but without the record,
Well, Lordship, otherwise I have submitted annexed the documents necessary as per my humble submission, Lordship, because we have duly submitted our written objection before the court below. And here in the order itself, Lordship, kindly for the middle portion, Lordship, just for my suggestion. During the course of hearing, it is submitted by the learned counsel of both sides orally that they have no objection. Lordship, there is an oral compromise, Lordship. They have no objection if the order of status quo is passed in respect of alienation and possession, Lordship. Others, Lordship.
Paragraph number?
Yes, Lordship. Paragraph number middle from middle, Lordship. During the course of hearing, page 42, last page. During the course of hearing, it is submitted by the learned counsel of both sides orally that they have no objection if the order of status quo is passed in respect of alienation and possession of the suit property during the pendency until the disposal of the main suit, bearing number 12. In fact, Lordship, we have submitted our written objection. That is, Lordship, I have annexed page 36, Lordship. And Lordship, without discussing the golden principle, Lordship, the three cumulative measures, Lordship, how, Lordship, this type of injunction order can be passed based on oral agreement, Lordship?
No, this is one consent order.
Consented order, Lordship.
Consent order. How can you challenge it?
No, Lordship. Because I have, that is why, Lordship, page 36 is my written objection. And Lordship, how, Lordship, oral consent may be valid, Lordship? It cannot be valid, Lordship.
No, you cannot challenge it.
Lordship, I am showing the authority, Lordship. Lordship.
So the trial court has passed the order.
Yes, Lordship.
As agreed upon by both the parties.
Yes, Lordship, but oral agreement. But Lordship, I am saying rule 23, order 23, rule 3. Lordship, it is clearly laid down that the compromise must be written and signed, Lordship, by the parties. I am showing the authority, Lordship.
No, you can show it from the authority.
Yes.
But you are party to this order, no?
Yes, I am party, Lordship, but I
No,
Lordship, I am denying, Lordship, I am denying
on that day you could have pointed out to the learned trial court that this cannot be accepted.
No, in fact, we did not agree. But the
Mr. Ahmed.
Yes, Lordship.
Let the record come, we will see.
Yes, Lordship.
Let the record.
Yes,
come.
Lordship.
Otherwise, you have no case.
No, Lordship, in the, Lordship, that sense, Lordship, I have also in the record itself, I have filed written objection.
Because why did you agree?
No, Lordship, I've never agreed. This is my case.
You could have very well pointed out to the trial court that this oral submission cannot be accepted.
Lordship, I cannot get it. Oral submission, Lordship, because Lordship.
In respect of this consent order.
Lordship. Yes, Lordship.
Could not be accepted by the learned trial court. You could have pointed out there.
Lordship, Lordship, because in that court, Lordship. No, in fact, it is, Lordship, our plea that we never, Lordship, consented because we have purchased the land by way of registered sale deed. And Lordship, how?
Okay, let the record come.
Yes, please.
Third, Mr. A.J. Ahmed, learned counsel for the petitioner, and Mr.
S.H. Rahman.
S.
Rahman.
S.H. Rahman, learned counsel for the respondent. Office note dated 9/4/2025 indicates that LCR has not yet, scan copy of the record has not yet been received. Accordingly, it is provided that Justice shall issue reminder to the learned trial court for transmitting the record without further delay, list the matter immediately after reopening.
How much your Lordship?